This matter will be taken after 2 weeks, my lord. I have taken consent of the other side.
On the prayer of Mr. N.J. Kathinia, learned counsel for the petitioner, list this matter after 2 weeks.
2 weeks, my lord. Obliged, lordship.
Please, your lordship. Lordship, with due consent of the other side, I beg to mention item number 59, lordship, the hearing matter. Yesterday, I had given the consent application, lordship, adjournment application, lordship. Mr. Y. Dolo, the respondent, counsel for the respondent is out of station. I am on his request, lordship.
You are?
I'm Mr. P.K. Bordle. I am on the request of Mr. Y. Dolo, lordship.
You are appearing for him.
On his request, lordship, on his behalf, lordship.
Mr.
P.K. Bordle.
P.K. Bordolo, learned counsel for the learned counsel appearing on behalf of Mr. Y. Dolo, learned senior CJC for the respondents. Praise for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks.
13th or 14th, lordship.
2 weeks.
Well, I want to mention item number 60 and 61, hearing matter. Whether matter may be taken upgrade by agreement at 2 p.m.
Not upgrade. We'll take it up.
There's some urges.
We'll take it up. Let it come its own turn.
Possible.
May I please, Your Lordship? I'd like to mention item number 34, my lord. Yesterday, we have received the affidavit in opposition filed by resolution number 3.
34.
To file reply, I have already informed the respondents, my lord.
Mr.
P. Sheikh, my lord.
33.
P. Sheikh, my lord. 34, my lord.
Mr. T. Sheikh, learned counsel for the petition of praise for and is granted 3 weeks time to file affidavit in reply to the affidavit in opposition filed by resolution number 3. Yes.
My pleasure, lordship. I beg to mention item number 12, lordship. So with the consent of the other side, matter may be adjourned, lordship.
Where?
So kindly fix it on 12th of August, lordship. 12th of August.
You are?
I am for the petitioner B. Borgunhai, lordship. B. Borgunhai, lordship.
B. Boru, on the prayer, Mr. B. Boru, learned counsel for the petition, list this matter after 10 days.
It's on 12th of August.
10 days.
May I please, your lordship? Lordship, I beg to mention item number 13, lordship. And for the respondent, my friend is for the petitioner, lordship. The matter may kindly be taken up after a week, lordship.
On the prayer of Mr. M.S.P. Sharma,
Sure.
learned standing counsel APSC. Let this matter be listed after 2 weeks.
Another lordship. Item number 22, lordship. My senior has some difficulty, lordship, today.
22.
22, lordship. Consent has been taken from the other side.
Why this further hearing? It's a part or what?
Lordship, yes, lordship.
On the ground that Mr. T.J. Manda, learned counsel, the senior counsel for the petitioner has some personal difficulty. Mr. M.S.P. Barwa, learned counsel for the petitioner, praise for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks.
Lordship, in item number 13, lordship may kindly fix a date, lordship, after 2 weeks, lordship.
13?
Any date after 2 weeks, lordship.
Why?
There's some ideas.
2 weeks, after 2 weeks. Keep
Any date. Lordship. Deeply obliged, lordship.
May I please, your lordship? I would like to mention item number 58. Mr. M. Dutta, he will not, some personal difficulties. He will not be able to appear. Kindly
Mr. M. Dutta, learned counsel, senior counsel for the applicant's personal legal. MS, your name, please.
P. Roy.
P. Roy, learned counsel appearing on his behalf, praise for listing of the after 2 weeks. Praise Lord, list after 2 weeks.
May I please, your lordship? Lordship, with regard to item number 38, your lordship. And for the petitioner here, lordship, I'm praying for some accommodation for today, your lordship.
On the prayer, Mr. D. Das, learned counsel for the petitioner, list this matter after 3 weeks.
3 weeks, lord. Much of this.
May your lordship? Lordship, I beg to state, mention item number 6. The matter has already been part heard. Kindly give another date.
If it is part heard, no adjournment.
Actually, my senior is not prepared for today. He's not prepared for today.
We'll take it up at 2 o'clock. Request him to prepare.
Oh.
May it please, your Lordship. With the consent of other side, I beg to mention item number 27, Lordship. We need to file affidavit in opposition, Lordship. 2 weeks time may kindly be granted.
You are for?
I am for the respondent number 18 and 19, Lordship. I am
Mr.
R. Islam.
R. Islam Land Council for respondent number 18 and 19.
18 and
Praise for it is granted.
I am
For the 2 weeks times to
am
file
for the
affidavit.
petition of.
Mr. K. Patkari Land Council petition.
Date may be fixed, my lord. Urgency in the matter, my lord.
What is the urgency?
My lord, regarding the seniority dispute, my lord.
What is the urgency?
My lord, going to retire in the year 2028, my lord.
28.
My lord.
Very long to.
Done, my lord. Well, date may be
27,
subject
we're yet to complete the 26.
my lord. Lordship, item number 48, so I need some time, Lordship. I have to take inspection regarding some non-payment of salary was there, Lordship.
48.
Lordship.
Mr.
M. R. Islam.
M.R. Islam.
Islam, R. Islam.
R. Islam Land Council for the
Petitioner.
petitioner fresh for listing of the matter. After 3 weeks, so as to enable him to obtain instruction, Mr. President, list the matter after 3 weeks.
Ablash.
May it please, my lord. My lord, I beg to mention item number 25 of the daily list. My lord, the senior counsel who is arguing this matter has some personal difficulty. He is not well, so he was unable to make it to court today. The matter
25.
may kindly be passed over for the day.
25.
Yes, my lord.
Who is your senior counsel?
Mr. Deenath.
Mr. Dean and senior counsel.
Yes, ma'am.
On the ground, Mr. Dean and senior counsel has some personal difficulty today. Mr.
G. Anthony.
G.
G. Anthony.
Anthony, land counsel appearing on behalf of appearing on his behalf, praise for listing of matter up to 3 weeks, prayer is allowed, list up to 3 weeks.
My lord, may kindly fix a date.
Why?
Oblige.
Wait, please, your lordship. Lordship, I would to mention item number 19, lordship. Consent has been taken from the counsel for the petition, lordship.
On the prayer, Mr.
P.N. Sharma.
B.N. Sharma.
P.N. Sharma.
P.N. Sharma, London Standing
Council.
Council, Elementary Education, fresh for is granted.
After 3 weeks, lordship.
3 weeks time to file affidavit.
Lordship, lordship. Or
Lordship,
instruction, lordship.
I am for the petitioner, Lordship.
Mr.
Item number 19 and 20, I am for the petitioner. I am R. Islam, Lord.
R. Islam, land counsel for the petition
I'm saying
is present.
item number 19 only. Problem.
It's connected.
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 May I please, your lordship? I beg to mention item number 18. Lordship, consent with the other side. My senior have some medical difficulties.
Pikedas.
Item number 18.
18. So I'm appearing for All India Limited in this case. No objection also.
Okay. On the prayer, MS.
Miss Jayadas.
J. Das, land counsel,
On behalf of
appearing on behalf of Mr. Pikedas.
M. Alom.
Huh?
M. Alom.
M. Alam, land counsel for the petitioner. Press for listing of the matter after 4 weeks. We had not been objected to by Mr.
Yes, sir.
A. Sharma and Mr. No, A. Sharma, and
For All India
counsel, All India Limited. Let this matter be listed after 4 weeks.
Obliged.
May be Lordship. In item number 28, my lord, we have received the affidavit in opposition yesterday. 3 weeks time may be granted to file.
On the
the
prayer, Mr. B. Kumar, land counsel for the Mr. B. Kumar, land counsel for the petition. Press for is granted 3 weeks time to file affidavit and reply.
I'm for respondent, SK Medium.
Mr. S. K. Medil and the CJC is present.
May I please, your lordship?
Hmm.
I beg to mention item number 51, your lordship.
Hmm.
Your lordship, here, due to the non-availability of the present address of some of the respondents, your lordship, we could not take steps upon the respondents. So, your lordship, we need some time to collect the present address of the respondents.
On the prayer of MS.
F. Shaheen.
F. Sahin, land counsel for let this matter be listed after 3 weeks for taking 2 weeks for taking steps.
Your lordship, kindly allow us to file the amended cause
It's
title.
up to you. You're
Yeah,
fine.
much of it.
Regulation 1 to 5.
Lord, Lordship's call for the report.
Yes.
Yes, but I have received a report, my lord. It is confidential.
Huh?
It is confidential.
What
my lord.
confidential?
What confidential, like the third party, my lord. It is a request made from the outside.
No, that's my lord, the fixation of rate is how it is confidential.
Everyone is nowadays on accountability and transparency.
We know only Evidence Act, my lord, where disclosure can be exempted. That too when an affidavit is filed by the central government Ministry of Petroleum Secretary. Other than that, my lord, I don't think any other method.
Some depends.
Maybe with security of the state. When your policy says that import parity price would be the determining factor.
This you have prepared recently. You have prepared recently.
No, my.
When? When
At
did
the
you
time
do
of
that?
auction, my lord.
Hmm?
Before the time of the auction, my lord.
Huh?
Before the time of auction, it has been mailed to me.
Where does it indicate?
First page, your lordship got it. The internal communication to the law department.
When?
Top, my lord.
When?
After,
Before or after?
my lord, after the passing of the last order, I have communicated to the authority to place the, my lord, calculation.
Huh.
And accordingly, that has been communicated by the concerned, my lord, department to the law department. And law department furnished this to me.
I think the Lordship is asking whether this was done prior to fixation.
That's what I'm asking.
Definitely, my lord, definitely, it was, it has to be.
No,
It
it
cannot
cannot.
be, my lord, made without, my lord.
No, it appears there's nothing, no seal, nothing, signature, no date, nothing.
My lord,
It appears to be
everything-
prepared.
But everything has been
By-
done
by-
digitally, my lord.
by
That is
now.
why, my lord, signatures, my lord, not required. Everything in the IOCL.
No, I think you may be justified in doing this, but now you cannot. This should be before the what is called auction.
Yes.
Yes,
Is it auction?
It,
Right?
Auction
auction,
was of 2024.
Ah.
auction.
No, 20. No, 24.
Reply to
conduct-
High Court, reply to High Court order
Oh,
only.
sorry.
It should be, your calculation has to be before.
2019, sorry, my
Calculation
lord.
was done, my lord, prior to conducting the auction.
It doesn't indicate. Nothing. No date, nothing. Okay, we understand your communication. It's in first page. The calculation is next page. There's nothing. No date, nothing. So we wondered, what is your justification before the issuance of, call for tender?
As,
Is that it? Auction.
My lord, what my lord, the authority stated, my lord, before conducting the auction, the calculation which was made, that has been provided in the sale cover. I also, my lord, did not see it, my lord, because your lordship, my lord, it was in sale cover. And while talking to in this regard, they said, my lord, the calculation which was made, that has been communicated now in a sale cover. This is the conversation between me and my lord, the authority.
This first page is what?
First page is, my lord, that has been communicated to the law department. It was addressed to the law officer of the department. By the concerned department, my lord, department is also not conducting this is the outsourcing. MST, who are also party in some of the writ petitions. MSTC Limited is a private agency through which, my lord, auctions are being conducted.
Achieve the stated objectives. Why this is confidential?
My lord, so far, my lord, the fixation of price is a prerogative of the authority who conducted the auction.
No, that has been done already. The price has been met. That has been done.
After, my lord, calculation, as per the guidelines of the, my lord, Ministry of Petroleum and Natural Gas, my lord, that has been, my lord.
So that's why this is confidential?
They said, my lord, it should not be disclosed to the purchaser. It should not be disclosed that the method of, my lord, calculation is a highly technical, highly technical issue for determination of the floor price. That should not be disclosed to the purchaser. This is the prerogative of the authority to
for future this thing auction.
For all the auctions.
No, that has already been done.
Well,
auction is over now.
That method is being adopted in future also. That is why this should not be disclosed.
You adopt different method in future.
The method which was adopted in the auction, which was challenged in this writ petition, that method will be, my lord, adopted in all the future auctions. That is the problem.
This cannot be, static.
It is up to your lordship. What is, my lord?
No, what I am asking is, why this is confidential? Because auction is over now. How you have calculated, what is the method, we would like to know. Because it doesn't indicate anything except the communication and the method you have shown. Whether this was done before or after. It appears to be after only.
Prior to the, my lord, conducting the auction.
Doesn't indicate.
That method has been applied and that has been calculated.
So
and
this.
In future, all the futures, my lord.
Okay, we're not saying that you could not have done it, but I'm
my lord,
I'm little anxious why this is confidential.
Confidential because, my lord, in all the futures auction,
as I said, you adopt different method. No. In future, this is over now.
That cannot be done, my lord. The same method will be applied in the future auctions also.
Now it is changed.
Now it's changed.
Change, my lord, no.
What? My lord,
that must be as per the notification. So as per the notification, whether they have done it or not, they must show it, my lord. How it can be confidential, my lord? I don't know.
My lord, the method.
My lord, let me come in, my lord.
This
is not rocket science, my lord. This is not security of the state. There is no national security is involved. And my lord, some officer's ego. Matter is very simple, my lord. The policy guideline is laid by the Union Minister of Petroleum and Natural Gas. And the guideline is it should bear, I mean, parity with the import parity.
Import price.
That's the only consideration.
On the basis of that, that has been done. my lord.
On the
There-
basis
there is-
of that, how can you have
on the
more higher
basis of that,
price?
That has been done.
More than
And my lord,
more than
the new policy.
No, when
as
it's,
per the new
no,
policy.
no, when it says that it has to be parity with the export policy, I mean price.
Yes.
How can you have a higher price?
No, that has not been done. That
That is
lordship may
done.
kindly see. my lord,
24, floor price
the
is
guidelines.
19
Lordship may,
something.
lordship may kindly see the guidelines.
Hmm.
Guidelines at page 27, annexure 2 of the writ petition.
Hmm.
The guidelines of the ministry,
Page,
page 27.
ah, yes. To ensure maximum revenue import price so and so should be used as a floor price in the bidding process.
To ensure maximum revenue, the import parity price
Hmm.
with freight charges, quality differentials, marketing cost, and margin, and other necessary adjustments should be used as the floor price in the bidding process.
Hmm.
That has been done by them. If your lordship see the calculation on the basis of these guidelines,
Hmm.
that has been done. There is no violation at all.
He has not seen, how he can see?
What do you mean by this import parity price?
Import parity price, my lord, that was disclosed in the.
My lord, the
Earlier
price which the imported, my lord, items are fetched, my lord. Imported items, my lord, are sold, my lord.
No, I'm just asking.
Yes.
You are saying that to ensure maximum revenue,
Yes.
the import parity price
Yes,
so and so should be used as the floor price in the bidding process.
yes. So that
So
cannot.
I'm
be-
asking, I mean, what do you mean by,
Yes.
according to you, what is import price?
Yes.
Import parity price means what? How you interpret it?
My lord, import parity price in, my lord, different auction is, will be different. On
Say,
the,
for example, here it's 19.
yes, my lord.
Can you have a different higher than this?
That, my lord, after, on the basis of import parity price, this adjustment and my lord, freight, marketing cost, margin, etc. has to be added. This, my lord, to ensure the maximum revenue. Revenue is the prime of, my lord, consideration. The import parity price with freight charges, quality differentials, my lord, refinery wise, my lord, quality are different.
So
From
you have
petroleum goods quality
according to you have adopted this method.
method.
So what's the confidential there in that case?
That, my lord, the authority said, my lord, that's, my lord, priority of the.
So
authority.
suppose according to you,
What are the margin, what are
just
the.
wait,
Right.
sir. According to the import parity price means includes all these things
Yes,
which could be higher than the import price. That is what you are saying.
yes,
That cannot be.
that's it again, guidelines too.
No, when you say that import parity price we could understand, includes this.
Right.
We could have understood. But when you use the word parity, that your submission negates this interpretation,
My
this
lord,
meaning.
Import parity price with, my lord, this with, my lord,
Hmm?
this with.
No, my lord, I think my
With
learned friend
freight-
is confusing with import price and import parity price.
Hmm.
My lord, import parity price is defined as the total landed cost
Hmm.
of buying a good from abroad and delivering it to a specific location inside the importing country. It includes everything.
Hmm.
I'm reading it, is the total landed cost of buying a good from abroad and delivering it to a specific location inside the importing country. So this is import parity price. Import price is different. Import parity price.
That's what I'm
Idea
saying.
is the local manufacturers should not suffer.
Yes.
Because if the import price is less, if the domestic production cost is higher, then local industry will suffer. That's why this balancing act is done.
Had it been simply import price with so and so, so and so, one could understand. But you have said, you use the word parity.
Since, my lord, this is a technical subject, my lord, fixation of floor price. If your lordship permits, I am also not expert in this regard as a layman, because it is a matter of required expertise. Then your lordship may, if your lordship permit me, I will call my officers to explain, my lord, how to.
It's not required.
If required, my lord. If required.
It's okay. We'll dispose of the
Yes.
matter.
My lord, so far, this is the parity price. Lordship, I have prepared a small list of dates and points which I want to argue that may be taken into consideration.
You want to argue?
My lord.
We have heard you. You just talk, you argue on this, you make a submission on this only. Why the import, say import price is 19, why you have, why you made it higher than that? Why you made it 24?
My humble submission.
Simply as per your, this thing, instruction and the method you have placed, it shows certain methodology you have adopted, including all these freight charges, quality, soil and everything, which comes to 24, higher than the import price. So prima facie, that is something which is not been the intention of this guideline, because it clearly talks about the import parity price. It's not simply say import price, right? That is my prima facie view. You just make submission on that.
My lord, fixation of floor price is totally the prerogative of the
Understood.
authority.
Understood.
My lord, where, my lord, expertise, my lord, persons is required. And in fact, they are saying, my lord, their pleaded case is that, my lord, they said, my lord, the price which is fixed in the auction, last auction, was on 7/6/2019, was in a higher side. That cannot be, my lord, taken into consideration in a writ court. That is my humble submission. On this point, I would like to, my lord, cite some decisions. First of all, 1994 6 SCC,
Tata Cellular.
Tata Cellular,
We all we know.
my lord, all, my lord, paragraph 94.
Jagdish Mandal.
My lord, Jagdish
All we
Mandal,
know have taken
my
care.
lord, 1972.
It's also
My
done.
lord, Harinarayan Jashwal's case. Then, my lord, employees of my lord, Union, Balco Employees Union versus Union of India,
That's also not.
my lord, and CPIL versus Union of India,
This is also not.
and one judgment that was on the Punjab of Haryana High Court. Lordship may kindly,
On what point?
my lord, regarding fixation of floor price. Regarding fixation of floor price.
Floor price of this RPC.
My lord, not only RPC, Lordship may kindly have a look of this, my lord, decision of the Punjab and Haryana High Court. Second page, last paragraph, my lord. Onwards.
Yes.
It is justifiably contended that auctioning of mining materials as per the policy of the fixing the reserve price is a policy matter, and the state, being a owner of the material, has a right to choose the best method in overall interest of the state. Reference is also made to an observation made by the court while disposing civil writ petition number so and so, the operative part of which is civil writ petition number so and so. Next page, my lord. State is the owner. It had a right to choose the best method by which it can collect the highest amount of revenue. Basically, the case involved to the question of policy when the state is decided to auction all the queries together.
Was
It
there,
has not been shown
was
that-
there any guideline?
My lord.
Was there any guideline in
Yes,
this
my lord,
case?
that is,
There was no guideline.
this is the guidelines, my lord, page 27.
No. Was there any guideline in this case?
Yes,
What was the guideline?
my lord.
There was no guideline in this case. It's simply whether the authority has the power to fix the floor price. That's all. We're not saying that you cannot.
My lord.
But problem is you have the guidelines. You have to adhere to that. That's the only
My
issue.
lord, as per my humble submission, the
If you want, if we may understand, we understand that if you say that if you have the interpretation of your own in this guideline, matter is something different, which we may understand. You may have the different interpretation. So you could have, relied the judgment of Central Coalfield and Monte Carlo. If that is your submission, because you said there's nothing wrong in the guideline that you have abide by this, you have
abide by the
added to this.
guidelines.
You have,
I have abided
mean,
by the guidelines.
huh?
That is my I have abided the guidelines of the central government.
therefore, the cases which
Better.
you ought
And
to
in
have
fact,
been
my lord-
relied is
In fact, my lord, all the
Central
petitioners,
Coalfield and Monte Carlo, not these cases.
my lord, in fact, in this case, all the writ petitioners were participated in the, my lord, auction,
Hmm,
which was challenged in this writ petition.
hmm.
And they have participated, lifted their materials, and then, my lord, they do not have, my lord, case now. Because there was no prayer for any refund of materials in any of the writ petition.
Okay.
That was subject to. That was
The
subject.
question of refund will come if the honorable court hold that the fixation price is arbitrary, illegal, and that is, my lord, higher side, which is a matter of expert. And it is a matter of civil
Writ
court.
petitions were filed before the completion of auction process
After, my lord, auction process is
initiated,
Initiated.
before the completion.
Yes,
before the completion, but they are participant, there was no interim order, nothing.
Ah,
no,
therefore,
That is very much there, my lord, 12/6/19 order.
Hmm.
It says that it will be subject to. After hearing the counsel, it is made clear that e-tender process for allotment so and so Gauhati refinery shall be subject to the outcome of the referendum.
ah.
Well, it is there.
See, suppose if we hold that you could not have fixed this plot price,
Yes.
consequential will follow because by now the auction process is over.
Yes.
Is not it, Mr. Sharma?
My lord.
Suppose
In
if
fact-
we allow the writ petition that you could not have and you have not adhered to the policy, in that event, consequential relief will be followed.
But there was.
Because there is something, this petition was filed before the completion of the auction process, right? Isn't
Their
it?
case is there.
But if we say that the writ petition, you have the power to adhere, you have, adhered the guidelines and all, then matter ends.
The pleaded case of the petitioner is there in this, all this writ petition. That the floor price fixed for the Gauhati refineries auction is higher than the other refineries. That has been justified by filing an affidavit. There are quality differential, and that is why the price of RPC of Gauhati refinery produced by the Gauhati refinery is different from the other refinery of the state.
But then you need to maintain adhere to the guidelines to maintain the
Yes,
import.
Quality
The price has to be, your floor price has to be parity with the, what is called, price.
Import parity price. My lord, in the, my lord, just provided list of that your lordship may kindly see, second page in our affidavit. In paragraph 4 of the affidavit in opposition, it is stated that e-auction are being conducted through MSTC Limited, public sector company, wherein the stipulated terms and conditions and the procedure adopted has been described. In paragraph 6, it has been stated that floor price has been fixed as per provisions of the guidelines dated 7/5/2012, issued by the Ministry of Petroleum and Natural Gas, Government of India. In paragraph 15 and 16, it has been described as to why the floor price of RPC of Gauhati refinery could not be fixed at par with the other refineries. In paragraph 7, it has been stated that Honorable Court, while disposing the writ petition number so and so and so and so, there were two writ petition filed in earlier two auctions by the same my lord petitioner. In its judgment and order dated 6/2/2019, rightly observed and held that pricing, or rather reserve pricing of RPC in e-auction is a highly technical subject in respect of which court may not have the requisite expertise. In such circumstances, court may have to circumspect in the intervening in such matter, and also held that it may not be proper for the writ court to venture into such matter requiring technical expertise. In paragraph 14, it has been submitted that auctioning of any materials by fixing the reserve price is a policy matter, and the authority concerned, being owner of the material, has a right to choose the best method in overall interest of the corporation, but cannot guide it by private interest like the petitioner who
Absolutely
are
correct.
concerned with the own profit and commercial interest.
You are absolutely correct. But problem is you have your own policy to have a parity of import price. So far as this case is concerned, whatever you are submitting, there's no, quarrel to that. You are absolutely right. But you have not adhered to your own policy.
Yes.
You have already had a policy by a guideline, is not it? That is the
Earlier, we have to follow the guidelines
That
issued by
entails
the
of this-
Ministry and Petroleum and Natural Gas. And thereafter, after 2022, we have to follow our own guidelines. That is the instruction from the central government. The oil companies has to follow their own guidelines.
Are you saying that you don't follow this guideline?
We have followed the guidelines.
You have followed,
We have
but
followed.
you have adhered to it according to you. That's all. Accordingly, you have done this.
Right.
It's okay. It's if they are saying that it's confidential, will not would like to,
Yes,
because
Lord.
this is something. This is only nothing. See, we had to be. There must be, and they say everyone is. Cramming for all this thing, and in fact, it should be accountability and transparency. Therefore, I'll just not show it to it, but then I'll just tell them they apprise them, they inform them this is nothing. This is nothing, sir. It's a communication between them and the method which they have adopted, which makes it 24
Milord,
something.
Milord, I'll just 1 minute reply, Milord. My learned friend is referring to those judgments. There is no quarrel with the proposition, Milord. It is not that we are asking your lordships to fix the floor price. We are saying in the matter of fixation of floor price, there is a guideline issued by the Government of India. You have not followed them.
That's all.
That is what has resulted in the difference of price of different units. But I can appreciate Gauhati refinery, if it is ₹1, then Boingao refinery, it could be 90 paisa because it is because of the transport. Or maybe Digboy refinery could be 1.10 paisa. But it can't be, Milord, Gauhati refinery, it is ₹1, and Milord, Digboy refinery, it is 50 paisa. So end of the day, it has to be rational. Rationality is one of the ground on which judicial review can be invoked. It's a case of absolute irrationality and illegality. There is a set of regulation in the form of the OM issued by the Government of India, and they're bound to follow that. Therefore, their contention, basically we are assailing the decision-making process. We are not questioning on the merits of the decision as to what should be the price. There is a disparity we have not followed, and that's why, this honorable court, on the last order, this honorable court was prompted to pass this order after seeing the records on 28/11/24. When the coordinate bench said, in order dated 28/11/24, please have a look at the order dated 28/11/24, my lord. It is seen from the record that the import price was 19,030. Respondent authorities shall place before this court the other details issue as to how the amount was arrived at 24,150. So we were not aware of this, my lord, because they produced some document before this honorable court, based on which your lordships could notice that import price is 19,030, whereas the floor price was 24,150. This prompted this honorable court to issue the direction, and now they have come up with that, my lord, formula. And moreover, my lord, two more aspects, my lord. When we file the writ petition before auction, we are allowed to permit without prejudice to our right and subject to outcome.
Just before that, where do you get this import price?
Because, my lord, they produced some document.
It's not on records.
It was not shown to us. It was shown to the honorable court, wherefrom the court found.
It was disclosed because initially it was not disclosed, but it was my submission on the particular day when that order was passed that the policy has been changed by the guidelines and notification of the central government on 29/1/2001. And my submission before before the honorable court on that day was that the matter has become infectious. That is why my lord,
I remember.
that is
Before
why,
this
my
court
lord,
also you said
that is
so.
why that price was disclosed.
Ah.
And since, my lord, a new process may adopted for fixing the floor price, but when I came back to the authority, they said, no, though notification has been changed, the same policy is adopted by the authorities in the process of auction. That is why that should not have been disclosed. That was the circumstances on which the honorable court disclosed the floor price. That was the.
And, my lord, we have also filed the additional affidavit, my lord, where we say in the event we succeed in the writ petition, they should refund it. No, Numaligarh Refinery has done it, my lord.
And I have also submitted the additional affidavit wherein I have shown that there was no loss sustained by the petitioner on the day on which the.
By additional affidavit, you said you sought for a refund if the writ petition.
When lords, we succeed in the writ petition, we are praying for a consequential relief of refund of the additional.
Although that fair.
Now, so far as the guidelines is concerned, is no longer there.
But
For future, it was not.
for future, and the guideline is of 22, and this is an auction of 2019. The guideline does not apply.
No, that's why I'm saying for future, I mean, this thing, it will not, this guideline will not be followed.
No.
It has already been, policy has already been changed.
Policy has.
So we'll be deciding on the basis on
Existing
that earlier existing.
The direction to the oil companies by the central government that you frame your own policy. You frame your own policy. We are not dictating you by issuing any notification or fixation of.
Now.
After 2022.
Now we are.
After the auction, which is.
The subject matter.
You can, yeah.
And my.
Yes, sir, what is trying to basically submit is essentially, he had added to the policy, page 27, that to ensure maximum, it includes all these within bracket, whatever is the with freight charges and so. According, they have calculated and they have adopted that method. Therefore, it's become higher than the floor price. I mean, the import price. That is what he said. He said we have not violated. We have rather added to it.
Some of the permissible components.
This is what he's saying.
But that will apply prospectively, not to this auction.
No, here. Earlier guideline, page 27.
Yes, it was said. Page 2012 guideline. But, my lord, going by the definition of import parity price, that is included, my lord.
Yes, that is what I wanted to know from you.
It becomes more than 25%.
I have done that, my lord. Kindly have a look at that. Import parity price is defined as the price that a purchaser pays or can expect it to pay for imported goods. Thus, CIF import price plus tariff plus transport cost to the purchaser's location. So the components which are indicated in 2012 OM, my lord, that is included in the import parity price. And that is why perhaps central government said that you should have due, adherence to the import price while fixing the floor price. Valued, and kindly see, my lord, you said market and trade glossary. Import parity price is the monetary value of a unit of product brought from a foreign country, valued at geographical location of interest in the importing country. So tomorrow, if we are to, my lord, import CPC from, my lord, sorry, RPC from abroad, my lord, the price which will be charged at Gauhati is the import parity price, which inclusive of transport cost, etc.
No, that I've understood, definition I've understood, but what he has said is this import parity price includes this the other charges, which has been given in within bracket.
That OM, yes.
Yes. Page 27.
Yes, my lord.
Therefore, it's become a floor price,
Yes.
though it is higher than the import price.
Iman?
Page
Now kindly see, my lord, with freight charges, quality differential, marketing cost, and margin and other necessary adjustments. Then, my lord, kindly see transport is already included in the price. They cannot charge it again. My lord, my humble submission is, my lord, when we say the import parity price, it will be the landing cost at Gauhati, going by the definition.
Yes.
So my humble submission is, my lord, this import parity price is a concept which includes all these components, my lord. And certainly, my lord, oil refinery is a commercial entity, my lord. They are also interested in profit. But being a, my lord, authority under Article 12, they also have to follow the other requirements, my lord. That is why in International Airport Authorities case, Supreme Court said, it is not that these conditions are binding only on the tenderer. It is equally binding on the, my lord, authority. So to say that they can add whatever they like, that is not the case, my lord. Otherwise, the government of the whole idea is to protect the domestic manufacturers, my lord. Yeah, these national policies are framed for what? For ensuring, my lord, equality. Because tomorrow, if the imported goods is cheap, who will buy the domestically produced goods, my lord? So these are the basic fundamental issues which needs to be addressed, my lord, while coming to such a policy decision. That's why Government of India said that it must be based on import price.
Yes. In fact, had you not disclosed the import price,
Things would have been different.
things would have been different.
Yes.
Now I think they say no. अपना पैर में कुल्हाड़ी मार दिया.
It was not.
Because it could be
It was not disclosed, but circumstances.
interpretation is open. It was open. Now it's no longer open.
My lord. I just want to rely one paragraph of Belgo employees judgment, my lord. 2002.
My lord, before my learned friends relies on that, Balco is a case of, my lord, where whether a particular industry should be handed over to private parties or not. It has got nothing to do with the case with
Anyway,
which we
sir, anyway, he's your.
My lord, that's
Anyway,
in
sir,
Balco's case, Supreme Court has used one very important
just one
sentence.
small paragraph I
That
want to read.
these
Anyway,
matters
anyway,
does not-
sir,
Okay.
let him enlighten us. He's your after your brother, your junior. Yes.
My lord, paragraph 95.
Just read it.
The offer of the highest bidder has been accepted. This was more than a reserve price, which was arrived at by the method which is well recognized and therefore we have not examined the details in the matter of arriving at the valuation figure. Moreover, valuation is a question of fact, and the court will not interfere in the matter of valuation unless the methodology adopted is arbitrary.
No issue. You are absolutely correct. While reading the Supreme Court, we're not disputing that. Okay. And Mr. GN Sayola, we'll go by the list.
Yes.
And most probably age also.
Yes. Certainly.
Hopefully, Sayola sir is
Yes.
elder than
Much. Certainly.
GN Sayola, Senior Counsel, assisted by Mr. K. Bhattacharya, Land Record, MS K. Bhattacharya, Land Council petitioner in WPC 5703 of 2019, 382 of 2019, and 383 of 2019. And Mr. Ken Chaudhary, Land Senior Assistant, Mr. Edas, Land Council 27 W 3880 and 5660. And also Mr. Dickerson, Land Assistant Council, Respondent IOCL. I'll pass the order.
Deep.
Not keeping it CAB. I'll pass the order.
Obliged.
Keep it inside.
Seven.
Fix key hole.
F2.
Oh.
In this case, my lord, the finance department was supposed to file affidavit, my lord.
Yes, finance. What is the matter about?
Here, my lord, they were regular employees, my lord. Now, subsequently, my lord, they were transferred to a, my lord, in fact, merged to a society, my lord, where they were asked to sign a contractual agreement. And the contract period was for a period of 11 months. My lord. So my whole contention was
You are regular employee of
Yes, yes.
actual sports what association?
it was a society otherwise, but it was, my lord, it was regulated
What
by
is
the state.
the amalgamation this thing order? Anything about your
No,
future of
no.
I mean
The
your
only thing, my lord,
about this service?
no, my lord. It was a simple order. In fact, my lord, prior to the amalgamation, there was already a decision, my lord, that the persons who would be appointed, my lord, they would be required to sign a contractual agreement.
No, that you had put to challenge.
Yes, my lord.
Is there any policy that you will be taken in the
No,
amalgamation?
it was not.
Then what is
not
your
specific.
basis?
Now, my case is, my lord, now, lordship, prior to amalgamation, I was.
Sir, it was in society. It
Yes,
has
both-
been
both are society.
amalgamated.
Yes,
right?
in fact,
Or
my lord,
merged with the new I mean the council, government council. Is not it?
yes, my lord.
Is it a merge with what?
Merged with, in fact, two societies were merged, my lord.
The Sports Council of Assam?
Yes.
Or the Sports Authority of Assam? The Sports Authority is also a society?
It's a both
Or
are
it's a
societies. Yes,
statutory-
both are societies.
Huh?
Both are societies.
Merged with Sports Authority? While merging, is there any decision
No,
or
my lord.
policy?
Lordship will page 33.
Hmm.
Merging, my lord, nothing was there. Page 33, annexure E, my lord. This was the merger.
In the
It was-
interest of the governor, pleased to merge the Sports Council of Assam with the Sports Authority of
This is
Assam.
under orders of the governor, my lord.
Then,
It's merged to the so and so.
if there is nothing, then
So,
what is your basis?
but prior to that, my lord, there is an order of this court
Hmm.
where the court says, my lord, that I'm entitled to all the benefits as that of a regular employment of the state.
When
Yes, my lord.
on being merged?
No, prior to that. Now, Lordship will kindly appreciate one thing, my lord. I was getting a salary of 36,000 prior to merger. My lord. This merger, my lord, then I am asked to join the subsequent society, my lord. There, my lord, I'm being given a salary of 2,000 something. From 36 to 2,000, Lordship will see. I was otherwise drawing the allowances and all in the regular pay scale of a government employee. Now, once the merger, my lord, I become a contractual employee with a rider that I may be terminated after 11 months.
Secondly, my lord, the structure, my lord, the pay structure, my lord. It was earlier, my lord, 36, it has come down to 2000 something. But that is why, my lord, the matter was referred to mediation. Thereafter, my lord, the finance department was asked to file an affidavit.
Proxy will have a look at the instruction, madam. Here the main authority will be respond number 3 and 6. Which 3 and 6? Director sports and your welfare. Assam.
I'm for PLC. No, it's not. Due to the problem of vehicles.
See, your earlier, your society, when it merges with the state sports council, no, sports authority of Assam,
Yes, my lord.
right?
Yes. Earlier, it was the state.
There's nothing, no decision, nothing. It
Yes.
goes. What is your right?
Right, my lord. Lordship, I'll just take you to the order, my lord. Lordship will kindly come to page. We were initially, my lord.
No, that is something different. You are there in the sports council.
Lordship.
It's a society, registered society.
Yes, ma'am. But it was, my lord, it was under the government of Assam.
Huh?
It was under the government of Assam, my lord, and Lordship will kindly see, my lord, initially, all the posts were created by the state. My lord, with the approval of the state, my lord, and the rules and regulations were of the state employees were governed by in the case, my lord. Now, page 20 for Lordship sees, initially, my lord, we came to this court. Lord, page 20 is an order of the High Court, my lord. Lordship will just come to that. The Honorable Court had held that I would be entitled to all the, these case protections and all. Revised pay scale and with there is an order of this court. If we
See,
place,
that was at the time of when you were in the society. I mean, council.
Lordship.
It has been merged along with the, it has been merged with this. There must be some decision by the authority to.
That is what,
what would be the.
Now, Lordship will see, that is what.
So now you cannot just that you had a similar pay scale and as that of the government employee.
No,
At the time when it was a society, I mean.
That is something different, my lord. Lordship will kindly appreciate. Both are societies, both are under the state. Earlier, my lord, I was getting a salary of 36,000, my lord.
So how you are, how you are agreed?
Agreed, my lord, why I came to this court is that, my lord, my salaries were withheld. Once I joined, my lord, we were not aware of such obligations.
Were you been allowed to join in the sports authority?
Once we joined, what had happened, once we joined, my lord, our salaries were withheld. When we made an inquiry, then we came to know that there is a order which says, my lord.
No, that's why I'm saying, where the, I mean, decision or the order, your service should also be.
Yes, my lord. I'll just
taken along.
Now, Lordship will kindly come to page 35. I'll just place. Page 35. Lordship has gone through the merger now, earlier one, 33. Page 35. Look, here, my lord, we were directed to report. With reference to the, I am to inform that the States Council of Assam has been merged with the sports so-and-so as conveyed by the government letter so-and-so. You are therefore directed to report to so-and-so and join the Sports Authority of Assam on one and the same in the same post that the Sports Authority positively. Now, Lordship, thereafter, Lordship will see page 37. We are deputed for duty. And thereafter, my lord, our salaries were.
This was by the Sports Council.
Sports Council, my lord. Sports Authority.
Page 30 is Sports Council. Then.
Sport. Now, Lordship will. Then we came to our salaries were withheld, and then we came to know it's of page 37, which has been impugned, my lord. This is an undated letter of July 2014, my lord.
Page 37.
Page 37. in pursuance of the recommendation of the committee considered as per the decision of the governing body so and so, held on so and so, to examine service matters of the staff of the Sports Authority of Assam, and approval of the same by the governing body held on 28th of February 2014. All the staff of the so and so is hereby asked to execute a contractual agreement with the Sports Authority of Assam as on 1st of November 2013. As a so and so with so and so. No claim for enhanced contract rate will be accepted unless the contract agreement is signed by the Sports Authority of Assam. Well, this was not meant to made not known known to us, my lord.
See, there must be something, a decision on the part of your service, future, this thing, service in the authority. There's nothing.
Exactly, my lord. No.
Once it's merged,
Lordship, that is my.
it's up to the authority to decide how they will engage, how they will, unless there's a decision to retain you, continue with the same salary, works and
Lord,
everything.
we did not go on our own, my lord. We were given the benefits of that of a state employee prior to that
Understood,
merger.
but then
It is under
there
the
must be some decision.
society is regulated by the, my lord, it is governed by the state, my lord, under the Board of Sports of Assam, which is under state government association. My lord.
Society means society, nothing else. Anyway,
Now, lordship will see.
what is to be done?
My lord, there will have to be some agreement, my lord, or under MOU.
That's what I'm saying. There's nothing, no basis. It's once you have, you just simply join there on the, direction of this Archwell, the Sports Council. You join, and the authority, this new, the society has taken a decision to have a contractual employee. What's wrong?
That is wrong in the sense, my lord. I was a regular employee earlier.
Doesn't matter. That has been merged along.
Merged by whom, my lord? By at least, my lord, that
Not the state government. It's between them. Maybe
Fine,
after
my lord.
the.
Is it not the state, my lord? Lordship will come to page 33. Is it not the
Are you
state, my lord?
challenging that?
Yes, my lord.
You are just
Lordship-
challenging.
No, Lordship will see. Is it not the state, my lord?
What you have to challenge is what would be your fate of your service in the new the society or the authority.
Now, Lordship will. This
Maybe a
person-
statutory authority, but then you have just simply joined on the direction of the actual the authority of the council,
my lord.
and then now authority has decided to have a contractual employee of
Lordship will
I
kindly
mean,
appreciate one thing. The merger was the.
to engage you on a contractual basis. What's wrong there? You could have challenged the merger when there's nothing, no decision or any agreement between these two, when it is merges.
Lordship, this is cases of 2000, my lord, 16. Lordship will see. The merger is by the Commissioner and Secretary of the Government of Assam, not my lord. So, my lord, if Lordship will.
That you challenge that, you have not challenged that. You are simply challenging the decision of the authority now.
Yes. No.
Suppose you are drawing every. I mean, you are given. You have been given everything. Regular employee kind of thing in the council. You are regular, no doubt. You had a. You may. It's not necessarily with at par with the government employee. You may have the higher pay also in the council. Now, once it is merges, your this thing, fate should have been decided before merger.
Yes, my lord. Now, Lordship will kindly.
Then you did.
You
didn't do anything.
Lordship will kindly come to page 14. My prayer.
Ah.
At that relevant point of time, my lord.
Yes.
Declaring the action of the respondent authority in withholding the salaries of the petitioner and insisting upon execution of the contract as being arbitrary, illegal, and unreasonable. Directing the respondent authority not to insist upon the petitioners to sign the contractual agreement in the in connection with the order dated nil. This is the, my lord, sending them to the, my lord, to the that is, my lord, to sign the contractual agreement. That will the Lordship at page 37.
See, contractual. Are you getting my point?
Yes, my lord.
You could have challenged when the merger took place.
Merger took place earlier, my lord.
That you have to challenge, because once it is merged to another authority, I mean to another society or whatever, there must be something, a decision to your service. That has not been done. You simply went on being asked by your earlier, authority. Page 25.
Yes, my lord.
Simply you went nothing. Then the new authority has the power and authority and the discretion to decide how the employee should be engaged, whether it's a contractual, whatever, maybe higher or better
Lordship will see,
perks and
my lord,
remuneration.
that ought to have been in the order, my lord, whereby, my lord, we were asked to join these.
That you have no challenge, you could have, that's why I'm just indicating, you could have challenged that. Anyway, who is for who is the authority?
My lord, here, my lord, if this is the position, my lord, let me have the instruction from the respondent number 1, my lord. At least what were the conditions of my lord merger in 2015? Only then probably this can be, this dispute can be resolved.
This is,
Respondent number 1 and 3. Yes, 1 and 3. And 3 is the director, 1 is the, my lord,
this finance is just simply saying that there is nothing, no
ultimately,
proposal.
yes, my lord, there will have to be, my lord, some condition, my lord, that they will be entitled for scale pay.
You file affidavit on behalf of this.
My lord, I will file my affidavit on behalf of the government as
government. This is what I was thinking.
The impugn order, lordship, that was of 2014, the merger was of 2015, my lord.
What impugn order?
The impugn order which says, my lord, that they will have to sign a contractual agreement, that was of 2014. And lordship, the merger was of 2015, my lord. Lordship at page 37.
Before the merger?
Yes, my lord. Lordship, that is what, my lord. At least we were not aware, my lord, that this kind of conditions would have come. Page 37, lordship will see, this is of July 2014. This is the impugn which has been impugned in this case.
There is nothing, no.
Yes, my lord. Now, lordship will see the merger at page, that is at a subsequent stage, my lord. So this is of
Well, it is
7th of September 2015, my lord. This is of 7 September 2015, my lord.
merger.
Page 33. So, my lord, a decision which was taken by the earlier.
No, this, your so-called impugn order doesn't, it's simply, there's no net, nothing.
Lordship will see page 37 for a moment.
37.
37, my lord, at the very beginning, it says, my lord, in pursuance of the recommendation of the committee constituted as per decision of the governing body, Sports Authority of Assam, held on so and so, to examine the service matters of staff of Sports Authority of Assam and approval of the same by the governing body held on so and so, all staffs of the Sports Authority of Assam is hereby asked to execute the contractual agreement with the Sports Authority of Assam as on so and so.
So, my lord, so and so as on 1st of November 2013. And
Well,
this
the
is
process for merger might have, my lord, was initiated at the time when this particular order was issued. Thereafter, my lord.
When did you receive this order? Page 37?
37 after we joined.
After the merger?
Yes, my lord. After we joined, my lord. That is what lordship will see. Person to them, my lord, we were not aware that there were some certain conditions there.
Anyway, heard, mister?
Are they?
Are they? Learned counsel for the petitioners. As prayed for by Mr. B. Gogoi, learned additional advocate general. Further, 3 weeks time is granted to file affidavit in opposition
On behalf of 1 and 3, my lord.
on behalf of respondent 1 and 3. List after 2 weeks. I think there may be a problem for you.
In fact, all of them have retired in the meantime. All of them have retired in the meantime.
DK? Buya, London. State Council.
Respondent number 6.
Which 6?
Respondent number 6 is
Sports Authority. London Council for Sports. Assam Sports Authority. Is present.
8 to 10. Item 8, 9, 10.
May please, your lordship. Yes. In item number 8, I am supposed to file the rejoinder. I could not file it, the person could not come, your lordship, because of the flood situation and all those things. Your lordship will kindly accommodate sometime. If it doesn't come on the next date, your lordship may take up the matter.
What is the matter?
Your lordship, this relates to the non-payment of the salary. The petitioner has been working in a health department in a grade 4 post, but all of a sudden his salary was stopped. No, so then he came up before this honorable court inter alia praying
What
that
is their stand?
their stand is that they have terminated me, your lordship.
Then?
Termination.
But
So you are challenging the termination?
no, your lordship, your lordship, when they say that they have terminated me, the termination order has to be communicated. It cannot be kept in a file, your lordship.
So you challenge that?
No, what I'm trying to say is
See,
that,
when you, since when you have not been paid? Since when? Since when you have not been paid the salary?
yes, your
You
lordship.
paid your salary.
Just a minute, your lordship.
Grade 3,
Yes, your lordship. I say that,
contractual, regular.
no contractual, no regular. They say is that I say that I have been appointed regularly. They say that it's an illegal appointment. And I claim that I have not been receiving my salary since December 2017.
2017.
Correct, your lordship.
Then, when you were terminated, shown to have been terminated. When you have been shown to have been terminated,
Specifically, they have not stated it, your lordship.
Totally illegal appointment, my lord, no advertisement, no select.
no, when you have terminated them.
My lord, they have out of the field. Already terminated, but there was an inquiry held, my lord, and thereafter it was terminated.
There is nothing on
There is
record.
no order of termination.
No, your lordship. There is nothing on record to say. That's what they say it, your lordship.
Respond number.
It is by the
67.
director of health service. Lordship will have a look at page 69, para 4. Well, at para 12, we have made the statement.
12.
Yes. And page 104, Lordship will see, my lord, why the salary was stopped. Termination order, sir.
Yeah, you have not received any salary since initial.
Since December 2017, your lordship.
No, since initial, from inception.
Yes, my lord. No record.
Inception.
In fact, the transfer orders are also fake, my lord. Not only the appointment, my lord. Transfer the-
104.
Your lordship, there is an admitted fact that I was working, your lordship.
Therefore, is thereby stopped with immediate effect until further then his appear. You have not appear also.
Your lordship, the,
You have been given opportunities.
as their case, your lordship, the admitted fact is that I have been working. And I'll
But
like to place one judgment. before-
Appointment is not there.
Your lordship,
Appointment is illegal.
your lordship, may I just place one judgment of the division
Huh?
bench?
Ah.
Your lordship will turn the next page, page 4. Heard Mr. Such and Such, learned senior counsel appearing for the appellant writ petitioner. Also heard such and such, learned standing counsel education department and such and such. The appeal was admitted on 4/3/2009 for limited issue of entitlement of the appellant to receive the salary for the period she rendered her service as assistant teacher in such and such schools. By an order dated issued by the Block Elementary Education Officer Borpeta, the writ petitioner was appointed as an assistant teacher posted initially at such and such college. Pursuant to the amalgamation of the ME section of the high school, the writ petitioner served as the assistant teacher of the high school. As the appellant was not receiving a salary pursuant to her appointment, she filed a writ petition claiming regularization of her salary and release of her salary. The learned single judge, on consideration of all the circumstances, found that the appointment of the appellant to be illegal and accordingly held that the appellant is not entitled to the reliefs claimed in the writ petition, leading to filing of this present appeal. From the counter affidavit filed in this appeal by the Secretary to the Government of Assam Education Department, the fact that the appellant served in the school is not disputed, and all that is averred is that the state did not compel the appellant to work and that she rendered her own service on her own violation, knowing fully that her appointment was ab initio void and illegal. Having regard to the above stand of the state authorities and admission contained in the affidavit that the appellant had rendered service as an assistant teacher, we are of the considered opinion that the appellant ought to be paid her salaries for the service rendered by her, although her appointment itself was found to be illegal. In the above view of the matter, we dispose of the writ appeal by directing the state respondents to pay her unpaid salary by taking note of the period during which the appellant rendered service.
When you were appointed?
Your Lordship.
When you were appointed?
Your Lordship, I've stated it, Your Lordship. My
Any
appointment is 19/3/2008. That's what I
Appointment,
said.
any appointment order?
Yes, Your Lordship.
Then you have received the salary from 2008 to
Your
2017.
Lordship, my instruction is that after I was transferred in 2013, I've been receiving salary. The salary was stopped in the year 2017 December on the plea that my appointment was illegal or fake, whatever my learned friend has stated. So that was the plea taken by them, but they have not denied the fact that I was working. There is no denial to that effect.
So thereafter?
So now, since then,
Since then, say from 2007, how long you have worked?
That instruction I have to take because they said that this is.
From 2017, you are claiming that you have not been paid.
Maybe.
How long you have?
Your Lordship, this.
How long you have?
This writ petition was filed in the year 2018. After my salary was stopped in December 2017.
For 1 year.
Yes. So thereafter, if he has
But then you have worked after the stoppage
that
of
instruction
salary.
I need to take, if Your Lordship, if he has not worked, I'll candidly submit that he has not worked or if he is terminated.
Better and clear. Tomorrow.
Tomorrow may not be possible. Your Lordship will grant me some time. At least till next Thursday, I'll get the instructions.
Monday.
Friday or Monday?
Friday won't be
This
possible.
Friday or
Next
Monday?
Thursday. Monday no possible. Monday no.
This Friday, my lord, after tomorrow.
Thursday.
Next
You have to-
Thursday, not this Thursday.
Because when you have terminated, when he was asked to appear,
Yes, my lord, regarding appearance for scrutiny, my lord. I'll place it.
yes, 2018.
And the other
It was
instruction they need to take is whether they have
2018
communicated the
also.
termination order to me.
By 19, my lord, the termination order was issued. And
Issued?
yes, my lord. Every
Where it
day-
is? Where the
My lord, in the next case, my lord, there is a termination order. I will place, my lord, on Thursday. I will place.
Thursday.
Your Lordship will take it on next Tuesday or Wednesday, Your Lordship.
Tuesday,
Wednesday.
Wednesday.
Not Mr. Bisina.
Arsena.
Oh, sorry, Arsene, learned counsel for the petitioners. Having considered that having considered the grievance of the petitioners being only of being claim of non-payment of salary since 2017.
December.
Since December 2017 till their termination from the service. Then counsel for the petitioner is granted a week's time to obtain instructions as to whether the petitioner has petitioners have served whether the petitioners were in the service till the termination of their service. Next parent, Mr. B. Gogolan, counsel to the additional advocate general for the state is also directed to, you have placed,
I place the termination order.
is directed to place the termination orders of the petitioners on the next date.
And also the instruction to the effect that whether they has communicated the termination order to the petitioner. Your Lordship.
No, communication.
Your Lordship, the Honorable Supreme Court has categorically stated simply termination is not enough. You have to communicate either in a paper publication or to the person.
Okay.
That they have to comply, Your Lordship.
And as to whether the termination order termination orders were communicated to the petitioners. You just taken in instruction
Yes,
whether it was communicated.
Deeply obliged.
Item 14. Yes, Your Lordship. Matter may be taken after some time. Lordship.
Why?
My senior is in some other court.
What is the issue here?
Matter pertains to compassionate appointment, Lordship. 14.
Yes, what to do? Compassionate
But
appointment.
actually, what happened, my lord? This is the compassionate appointment. Father died, my lord, 2011. Now, my lord, 2026, more than 1400 years. So his case cannot be considered. Moreover, my lord, whatever he stated in this matter, narrated in the repetition, that is totally false. Lordship, kindly see our affidavit. We have filed an affidavit. That's point number 2. He says private respondent number 6 and 7 is going, or 5 and 6 is going to be appointed. In fact, my lord, respondent number 5 and 6, my lord, aged about 61 years. How it is possible?
Huh?
Aged about 61 years. How it is possible? Lordship, our affidavit, Lordship, can you see?
Page.
Internal page 3, my lord. Paragraph 7. The one back to state that the SLC was held on 1st March 2022, but the petitioner case was not placed before the SLC as it was not recommended by the DLC, which is prerequisite for the principle 7 of the office promotion. It is a vital point, my lord. That was not placed before the SLC, and SLC not recommended his case. How, my lord, it possible to consider his case? And more so, however, it is to be mentioned that SLC on 1st March 22, none of the case placed before it were considered, and deponent was directed to resubmit those applications. Department was directed to resubmit those applications fulfilling the condition laid down. On that SLC also, no case was considered. And paragraph 8, 11, against para 11 and 12 of the petition, that is for the back to stated, the statements are not true and accordingly denied. The tourism department has not made any move to consider the case of the respondent number 6 for appointment on compulsory ground in lieu of the respondent number 5, that is recommended candidate who is now 61 years old. There is no question of considering respondent number 6 as her case was rejected in the DLC on 31st October 2014. Paragraph 10. The answer is back to the tourism department, Government of Assam, has not made any move to consider the case of the respondent number 6 for appointment on compulsory ground. Appointment on compulsory ground is subject to fulfillment of the all conditions, including availability of vacancy laid down for the appointment, so and so. And paragraph 12. The tourism department, Government of Assam, has not made any move to consider the case of the respondent number 6 for appointment on compulsory ground. The case of the respondent number 6 was not considered along with the others by DLC on 30th of October 2014. The petitioner is trying to mislead the court. This is the fact. That is the state ballot. Actually, ballot, what he has stated in the writ petition, Lordship kindly see, all are fact. Not true.
Where is the recommendation?
No recommendation.
Where is the
No
recommendation?
recommendation. His case was not recommended by the DLC. The question of placing before the SLC does not arise. As the foremost thing is that department has to submit his application and to place the DLC under the deputy commissioner of district. Then it goes to ballot for further consideration to SLC. SLC will be the final authority to select it or not to select it. That's why ballot his cases, I think no case, otherwise the Robert Tibari case is there ballot. The cases cannot ballot existed, cannot be subsisted ballot.
Page, come to page 40.
Page, page 40 ballot. Statement showing the details of the application, so and so, so and so. Under a compulsory appointment, officers. Name of the officer, director of tourism department. 10 numbers. Grade 3 post. Name of the applicants.
Column 8, remarks.
Niva Bora and Ranju Soikia Hazurika and Pradip Teka. Whether the application was submitted within 1 year or that. Yes, yes.
Come to 8.8.
My lord, this is the, I don't understand, my lord, why this only signature is, my lord, made by the deputy commissioner. The state level committee, there is a so many persons is there, my lord, including departmental.
No, what you have said that his name has not been recommended.
Yeah, not
His name is not, what he's saying is that he's financially more weaker than the person whose name has been recommended, right?
This is
It's true,
not
as
true.
per page 40.
No, page 40, my lord, I have seen DLC not made a signature.
Panju Soikia Hazrika has been recommended for grade 3 post based on weaker financial condition than the other applicants, Sri Pradeep Deka and Sriman Niva Bora.
That is, my lord, in the affidavit denied it.
You cannot say that. This is
If we deny it, my lord, how petitioner?
how can you deny it like that, sir?
My lord,
This is the signature of Deputy Commissioner.
Deputy Commissioner, my lord,
Where you have
DLC
denied that you have Deputy Commissioner has
DLC
not issued this
Can
order.
you see DLC, there is other members also there.
No, it's not that. Where your denial of this page 40.
Page 40, my
You are
lord.
simply is not a they cannot be treated as a gospel truth.
No, my lord.
We understand.
Annexer, I don't know what is the Annexer 7.
Huh?
Lordship, kindly see the statement of against the Annexer 7. 7. That the petitioner begs to state that there on the 5th of November 2014. By letter that the Deputy Commissioner Kamru Metro Chairman of District level.
Where you are reading?
Yes,
Where you are reading?
7, paragraph 7, page 8 of the
Ah.
petition. Chairman of the district level committee forwarded the aforesaid 3 proposal of the petitioner, the respondent of 5 and the respondent of 6, along with the minutes of the GLC meeting on 31/10/2014. to the Secretary to the Government of Assam Tourism Department. That is, my lordship, our answer is lordship, can you see in the affidavit?
Where is the denial?
Yes, I will give you.
Where is the denial?
Paragraph 5, my lordship. Paragraph 7, my lord. With regard to a statement made in paragraph 10 of the repetition of the different best to state that SLC held on 22, but the petitioner case was not placed before the SLC.
Paragraph 7.
Though it was recommended, as per these documents, my lord, he says they recommended 3 persons, but that was not placed before the SLC. As it was not recommended by the DLC.
Come to page 2, your internal, para 5.
Paragraph 5.
Reporters is to state that these are matter can as such answer does not begs to offer no comment.
There is no comment because, my lord, it is annexed as a.
That's sir, when you have said that
It is annexed
it
as a,
has
my
been
lord.
denied, you have not denied this. You rather admitted it. It's a matter of records.
Yes, it may be matter of record.
This
But we have denied.
see,
it was-
annexure 7 is the above is made in para 7 of the writ petition, page 40.
But we denied in the affidavit, but another paragraph is there, because that case was not placed. Maybe
See-
that was not placed before the
It
SLC.
doesn't say. that.
Assuming, my lord, it is true, the case was not placed before the SLC. So how? his
No,
case-
what he is saying is his case is that
Recommended.
he is more weaker than the person whose name has been recommended
That's point number
by
5.
the deputy commissioner. You said that you have denied that there is nothing like that.
Yes,
Para 5 you read.
para 5, my lord,
They have made this statement in para 7 of the writ petition.
yes. And our reply also there, my lord.
Your reply is that para 5.
But our reply is that.
Statement made in para 5, 6 and 7 writ petition, the department state these are matter of record as such
Yes.
answer begs to offer no comment.
Yes, it's a matter of record.
But you have
That's why
said
we have not.
while ago you have
But we are denying
said
it.
that you have denied.
My lord, our affidavit, we denying it, my lord. Our affidavit, we denying that.
Why you have denied that the
that
other
is-
person has been recommended?
Yes, paragraph 7, our affidavit.
What does it say?
That's why, my lord, I have said it is not true. He was.
Sir, are you getting what you have said that there is nothing like recommendation? No recommendation is made to anyone, right?
Yes.
Therefore, this is false.
No, lordship, can you see the.
They made a amendment in para 7. Your reply to para 7 is at para 5 of your affidavit, where you said no comment.
My lord, this affidavit is filed by the. Responsible to the district Kamrul. My lord, near no comment, it does not mean we are admitted it. No comment means because they have annexed one letter. This document, we have nothing to say. But that document, whether it placed before the SLC or not, if it is not placed before the SLC, how about a petitioner case and other case will be
Who is
considered?
there? Who is the respondent number 2?
Respondent 2 is a additional district commissioner. No, he's a district commissioner. Working as a joint secretary, my lord. This is government, my lord. So, government joint secretary to the Government of Assam Tourism Department has filed this affidavit. This department, under whom he is seeking, my lord, appointment on compassionate ground, that is, my lord, they denied it. No, we are not considering anything. Maybe in a deputy commissioner level, that records may be there. They were recommended. Assuming they were recommended, but that was not.
No, I'm not on that. We'll hear you on that. What you have submitted is that page 40 is a fake document or it's a false statement. It's a false record. As because there's nothing, no recommendation made to anyone.
Yes.
Then you have your paragraph is page 7, which has
Yes.
been made in para
Yes.
7 of the writ petition.
Yes, no one
Then
recommended.
your reply is what?
My reply, my lord, is says the tourism department, that was the document, the on record.
These are matter of record and
That-
as such the answering
but
government makes to
record does
offer
not
no
mean-
comment. What does it mean?
Record.
Are you denying that the existence of these
No, no,
documents?
I'm not denying that it's a record. We are admit that it's a record. But
Yes.
this record is. actually-
Record means it's not a
No, no, my lord.
false.
Whether these records is acted or not. Upon this.
It's not a question of acting. It's a
but-
question of replying whether this is correct or
Yes,
false documents or
actually,
not.
We have admitted written records,
Yes.
matter of records.
Then?
We have no comment.
Huh?
Okay. Whether.
Then you could have submitted that. Why you have said that this is a false claim?
Kindly bear with me, my lord secretary.
It's not a question of bearing. I've been bearing in the last 15, 20 minutes with you. You have said something else and the affidavit says otherwise.
No, my lord, I am not saying like that. I am saying that ultimately the tourism department has filed this affidavit saying that no person was recommended and no were going to be appointed.
What does it say?
Your lordship, policy, paragraph 7.
The next is the SLC was held on, but the petition case was not placed before as it was not recommended, which is previously. This is something different.
No, my lord. Paragraph 10, we have said.
He never said that his case was recommended. What he has prayed is that I am a better, candidate is because I am weaker than the person whose name has been recommended.
Yes, sir.
That is his case.
If the
Your stand is that this was not, his case was not recommended or placed before the SLC. Who is disputing that? Because his name was not recommended.
his claim is he's a more weaker than others.
That's all.
His position is better than others.
Yes.
So if nobody is recommended, the where question of a better.
Where is no question of not recommended? Somebody has been recommended. Page 40.
No, my lord.
Page 40 has been recommended.
Yes. The petitioner name is also there. I am not saying.
And you read the next para 7. It is to be mentioned that SLC of so and so, none of the cases placed before it were considered, and the department is directed to resubmit the application fulfilling so and so.
Yes.
What's the question of not recommended?
Oh, my
You
lord.
said that nobody was recommended.
My lord, Lordship kindly.
He said recommended persons were not being considered.
No, he says like that.
Not he said.
Consider. No,
You have said so.
no, yeah,
You read para 7, sir.
yes. Deponent begs to say the SLC was held on 1st March 2022.
Huh.
But the petitioner's case was not placed before the SLC.
As it was not recommended by the
DLC.
DLC.
We said as per
Just wait.
7 of the government.
Just wait. Because his name was not recommended. It's a fact. With no one disputing. He's also not saying that his name was recommended. What he is saying is that he is better, weaker, financially weaker. Therefore, I may be considered in place of the person whose name has been recommended. He's financially
Yes,
better.
yes,
Number 2.
I have understood.
Therefore, you have said that his name was not recommended. It's a fact. He's not saying that his name was not recommended.
Yes.
Come to the second para.
Yes, that's why I'm saying.
He said that
had it been
all these,
recommended,
none
not
of the cases placed before were considered and the department was directed to resubmit.
Yes.
Please read it.
Whether they submit or not, Bala, I
Well,
don't
it's
know.
not a question of not placing it.
No, Bala. He's saying that he's a better position than other person recommended in the deputy commissioner. Okay, assuming recommended. But had the other person been placed along with him in the SLC and considered it, then he can claim that I am a better position, I am very weaker, then comes. But beta is not considered. That how it comes.
See, what you are trying to submit, you are evading
I'm
now.
saying
Your
that-
submission become an evading. Your
If
submission.
person recommended.
See, what you have initially said is something you are diverting from that.
No. I am saying, my lord, what I am saying, my lord, this 3% recommended.
You are completely diverting from what you have submitted earlier.
No. What I am saying that no one was recommended. No one was considered. No one, that 3% were, I think, assuming a deputy commissioner recommended. But that was not considered by the SLC. Not placed before the SLC, that's why not considered. There is a question of
SLC, which
suppose, my lord,
no,
out of 3%, let me submit, my lord, say, out of 3%.
nobody was placed.
No, not placed. Don't place.
Read second para of the para 7.
It is to be
Sub
mentioned
para.
that the SLC on 1T, none of the cases placed before it were considered. And the department was directed to resubmit those applications fulfilling conditions laid down in office memorandum. That was the
What does it mean? None of the cases placed before it were not considered. That means it was placed.
No, sir. Not this other cases also, other department also there. On that sitting.
Very strange, sir.
Yes,
I
sir,
didn't, sir, I didn't expect from such a submission from the senior counsel like you.
No, my lord. What I
We'll
will
take it up
submit-
after 5 minutes.
After 5.
You think about it.
Over to the. কি বুঝে আমার seven, my lord. Second paragraph, my lord. However, it is to be mentioned that in the said SLC on 1st March 2022, none of the cases placed before it were considered. None of the cases placed before it does not mean that only the petitioner case were not placed. Other cases are also there. SLC. Suppose it is a tourism department or a irrigation department, PW department, no other department cases were considered. Because department was directed to resubmit those applications fulfilling condition laid down by the office member of 1650.
Sir,
Yes.
actually what this court had got to irk is, what invites the ire of this court is that you have initially submitted, you may be correct now. You may be correct now. Initially, you have submitted something else which is not, I mean, consonant with the record, or rather the contrary to the records, the statement, the reply given by your department. That is, it got little, otherwise nothing. You may, now you are, I mean, you say, no, they say, Oot pahar ke niche aa gaya. Now you are correct. Now you are correct.
That is why
What I had to tell you is that I was surprised.
Yes.
That's why it's nothing like nothing personal, but then I was little which is irked me because you have submitted something which is contrary to the records. That's why. And you said you didn't have a courtesy to say even, yes, that see, we commit mistake.
Yes. No, no, Manoj, what
We also commit mistake.
I am submitting from the
Unconsciously, subconsciously. No, that's your submission. It was totally, absolutely contrary to what is stated in the affidavit. This is what I'm trying to tell you. Right? Anyway, forget about that. Unnecessary where we spend thing. I thought that you realize. Anyway, but we want really, I mean, especially from
sorry, my lord, if there is any
like you, sir, we expect a fair submission.
Sorry, my lord, if there
Fair
is any wrong
submission.
submission, lordship may.
But it's okay. It also is nothing. Nothing personal. But we expect the fair submission.
I am submitting from the affidavit only.
Affidavit wrongly you have submitted, or you have misinterpreted the affidavit. Anyway, let us not go into that. Now, what can we do now?
Now, my lord, what
You want that it should be resubmitted. So we'll direct the respondent to consider his case and resubmit it.
Resubmitted, my lord, one thing is there. Those who fulfill the condition. If you going through the fulfill the condition, our the office member is there.
No, another problem is it's no longer there. When is the policy is no longer there?
Yes.
This is difficult. You think about it. We'll direct the, because you have said they is directed to resubmit those applications fulfilling the conditions as laid down to so and so. We'll consider your case.
That was the condition of 2022. Now 24, another notification has come. Those who cases are pending for 2 years, not considered, it cannot be considered again. On the basis of Developer Tiwari, paragraph 7.5. May I read it, my lord?
It's okay. Heard Mr.
PB Gauhati.
Learned content for the petitioner. Yes, spread for by the parties, let this method be listed after 2 weeks. On the next date, matters shall be taken up for final disposal.
Obliged, my lord. First day.
15.
15. First day. After 2 weeks. Well, in this matter, my lord, we have filed affidavit today. We have copy today to him.
Okay.
Yes, copy here.
And Mr.
A. Anna Ahmed.
A. Anand. N. Ahmed.
A. N. Ahmed.
And Land Council for Deputy. Next paragraph, it is submitted by Mr. T.C. Suti, the senior counsel for the state restaurant submits that An affidavit in on behalf of the state has has been filed today. We're serving the copy of the same to the land council petition plus. And we will let this matter be listed after 3 weeks.
Yes, Malad.
16 and 17.
This is a matter, my lord, 16 regarding. Okay, sir.
আপনি এফিডেভিট ফাইল কৰিব লগা আছিলে যে কৰিম
Apply করবে। Apply file করছো তো?
নাই কৰা সেকেন্ডত
এটা তো?
সেকেন্ডত
Second, একে হয়ে জানো?
নাই নাই একে নহয় আমি পঢ়ি আহিম
আচ্ছা, আচ্ছা। Second to social.
Your Lordship, there was some anomaly in the selection process. The first case was filed, item number 16 was filed challenging the selection process. And during that selection, during that pendency of that writ petition, we came to learn that there were some anomalies by the respondents in conducting the selection process. So thereafter, subsequently, we have challenged the second writ petition is the challenge brought on record to the anomalies they have done in the selection process, Your Lordship.
Yes.
So they were required to file the affidavit, Your Lordship, today, or to produce the records.
Who has filed this?
Malad, first 16, item number 16, Malad, we have filed affidavit. And he says the item number 17, we have not filed affidavit.
Okay.
So let me.
Not Mr.
At that time.
Arsina, land counsel for the petitioners. Same person,
Yes, Your Lordship.
petitioner.
Yes, Your
Ah.
Lordship.
It is submitted at the bar that an affidavit of opposition has been filed in WPC 6-2.
No, no, 2688. They're supposed to file the affidavit in 2688 of
To
2020.
4608 of 2022. Right, it is submitted at the bar that an affidavit of opposition on behalf of the state has already been filed in WPC 4608 of 2022. List of. List of, however, an affidavit. Please, not however, list of, it is also submitted that affidavit in opposition would be required in WPC 2688 of 2026. List of, therefore, press for, therefore, no, list of be above. Let this matter be listed after 3 weeks. In the meantime, Mr. TC should learn counsel for the state respondent shall file affidavit in opposition in WPC 2688 of 2026. Okay.
Malad, repetition, item number 17. We have not, Malad, I don't know whether I receive or not. The copy is not with me. Let him file the.
Yes,
One
sir.
copy, madam.
Yes, sir. What is
We
it?
have already served long back, Your Lordship. This is on the third occasion the case.
It's 2026 case, my lord.
That's what I'm
Yes, sir.
saying.
What's there? Sir.
If
one
he
copy.
wants, I can again submit him, Your Lordship.
That's why I am paying.
Your Lordship will ask them to positively file this affidavit in the
I
next.
said so.
No, why I'm saying so, this case is languishing since 2022.
But I
This-
said last one. 22, they have already filed.
No, Your Lordship will appreciate the
Yes,
fact.
yes, last line. Nor is there. In the meantime, Mr. TC Chutia, learned state council shall file the affidavit. Positively.
I'm deeply obliged.
After she, Malad,
You
he.
serve a copy. Yes, one copy.
Obliged, madam.
Item 21.
My pleasure also.
Yes.
So this matter relates to the releasing of the death cum retirement gratuity among lordship. That was lying in the office of the accountant general. Kindly see-
Yes, where is the account general? They filed the affidavit.
No affidavit has been filed, lordship. I
It is
have-
pending before the accountant general.
Yes, lordship.
Huh?
And during pendency of the case, lordship, there is a settlement arise between the private respondent and the petitioner. And they agreed to receive 50% of the that amount, lordship.
Then
So I have filed this IA regarding this, lordship.
IA,
IA number 866.
item
Item 21.
21.
Yes, lordship.
IA for what?
IA for releasing that amount, 50% to the petitioner and 50% to the respondent, lordship. Private respondent.
So because of dispute between you,
Sir.
it was not released.
Lordship, I don't know why that was not released, sir. And
Yes, who is for, you said that it's pending before the Accountant General.
Yes, Lordship.
Huh?
Sir, my senior is in another court, so pray for timing, sir.
After some time.
Problem.
Item 23. Item 23. Proceed when receive the instructions from the department of SIP. We need some time to get instructions.
Non appears for deposition on the call on the prayer of next prayer on the prayer of
Pija on behalf of DP.
Huh?
Pija.
Pija, Learned Counsel appearing on behalf of
DP Bora.
Mr. DP Bora, Learned Counsel, Standing Counsel, Family Health and Family Welfare Department. Further 3 weeks time is granted to file affidavit in opposition. Yes, next.
Yeah, Lordship, for 23 ma'am is there. Bornali ma'am is there, she is coming. I think.
No, it's okay. They want to file affidavit.
What's up? 24. 24.
Then you record in place of non appears, huh? MSB Chaudhary, Legal Aid Council. Where the petitioner is present, huh? Yes, 24. Non appears for the petitioner on call, list after 4 weeks. 4 weeks.
Item 26.
Lordship, here I pay for some accommodation, Lordship, we have to file.
Yes, heard, Mr.
M. Rahman.
M. Rahman.
On behalf of P. Bharadwaj.
Learned Counsel appearing on Vati Bharadwaj, Learned Counsel for the petitioner. Petitioners.
Yes.
Petitioners next. As prayed for by Mr. P.N. Sharma, Learned Standing Counsel.
Elementary.
Elimination. Further 3 weeks time is granted to file affidavit in opposition. Am I clear now?
29.
Your Lordship.
Ah.
Lordship, my senior will join shortly. Ask for time.
Hmm?
I asked for time.
Who is for the petitioner?
Sorry, Lordship, respondent side.
You want file sometime to file affidavit?
Yes, Lordship, I have no instruction about that. Please wait for my senior.
We'll wait for your senior.
I asked for time.
When he would like to, he would leisurely like to come.
I apologize, Lordship.
Huh?
I asked for.
Also, affidavit has been sent for vetting, Lordship.
Okay, non-appears for the petitioner on call. MS
R. Devi.
R. Devi, Learned Counsel, Standing Counsel for Learned CGC submits that an affidavit has been sent for vetting. Therefore, phrase for listing of the matter after 3 weeks. So as to enable her to file the affidavit in opposition. Praise allowed, list the matter after 3 weeks.
I am input S1 number 7.
Mr.
S new.
S.
New.
New. Learned Counsel, but the respond number
7.
7 is present.
30.
My lord, in this case, I am appearing for the respondent, my lord, we need for the 4 weeks time, my lord.
And Mr.
Eboro,
Eboro, Learned Counsel for the petition on the prayer of Mr. SK Singh.
BK Singh.
Sorry, BK Singh, Learned Standing FCA, for that 4 weeks time is granted to file affidavit. In
Any date may be given, my lord, because plus 2.
4 weeks, just keep that.
Plus 2.
Obliged.
Occasion they are taking time, my lord.
4 weeks.
20. Obliged. Lordship, in this matter, I require 1 week's time. We have filed a reply. Affidavit is also complete. Just I want some instruction regarding
You want to file reply?
reply we have filed, but
Mr. BP Bora, Learned Counsel for the Prisoner's Price for is granted 2 weeks.
2 weeks.
2 weeks time to file affidavit in reply. Mr. Use PK Goswami. JK Goswami, Learned Counsel for the petition, Learned Standing Counsel, Additional Advocate, Additional Senior Government Advocate is present.
Give.
32.
Non-appears for the petitioners on call. Non-appears for the parties on call list after 4 weeks. Non-appears for the petitioner on call, Mr. J.K. Goswami, Learned Additional Senior Government Advocate is present. You have filed the affidavit.
Yes, sir, I will file it.
Mr. J.K. Goswami, Learned Counsel, Additional Senior Government Advocate, phrase for and granted 3 weeks time to file affidavit, list after 3 weeks.
35.
In this case, I am appearing for the respondent, my lord. A date may be fixed for disposal of this matter.
What is the matter about?
Matter is, my lord, a disciplinary proceeding, my lord.
Okay,
Same date, my lord, 28th of August.
okay. Heard Mr.
G.K. Gupta.
K.K. Gupta, Learned Counsel for the petitioner. We'll fix it on 28. We'll admit the petition, list for hearing.
Yes.
Admit, and also had Mr. B.K. Singh, Learned Standing Counsel, FCI for the respondents. Admit list for hearing on 28/8/2026.
Oblige yours.
36.
Spend some time.
Better we pass over the timing.
What is the matter about?
Lordship, we have access all, we need to file our affidavit, Lordship.
Okay. Heard Miss MS
Aye.
K. Learned Counsel for the petition. Mr. P.N. Goswami, Learned Standing Counsel, Elementary Education, praise for and granted 3 weeks time to file affidavit.
37.
Thank you, Lord. My lord, in this case, my lord, record was called for from the Deputy Commissioner Nalbari, my lord.
Yes, Lordship, we have received the record and on last occasion, the query is that whether family members' marks, 5 marks was added to the petitioner or not. It is as per our record, it is added, Lordship. He get 5 points extra as family member. Yes.
So my lord, question is that the categories, my lord, the family category Mojudar view.
Heard Mr.
HL, my lord.
Huh?
HL.
HL Learned Counsel for the petitioner and also heard MS
S. Borua.
S. Baru, Learned State Council.
Or 3
Ajal.
and 4.
For
3 and 4.
Labor Respondent 3 and 4 and Mr.
Yes.
S. Alam, Learned Counsel Respondent. Admit list for hearing when?
My lord, Gaubura Foods, my lord,
List
admission
for
hearing, my lord,
when?
it is
When?
September, my lord, any date, my lord.
September.
September, August or.
No, then you just say, as prayed for by the parties, let this matter be listed. After 3 weeks,
The date may be fixed.
MS M. Barua,
S. Borua.
S. Barua, Learned State Council to retain the records.
Date may be fixed, my lord.
3 weeks.
37.
Which should August? September in the month.
Condition hours, yes, my lord. No.
Make it 4 weeks? 2nd September, 3rd September. Next. Yes.
Now, here is the matter related to Constable ZD, the rejection by the RME. On the last occasion, according to our Honorable High Court order, he was examined by the GMCH for perforation of hearing. And that's medical report, I think, is there.
Yes.
Yes, Lordship.
Yes.
Here is the perforation is now completely okay and is compatible for the Constable ZD for rejection. But there is a two board, RME and DME, and final rejection is by the RME. And immediately he goes to the GMCH and his transferring membranes and hearing performance is totally okay. And that our Honorable High Court order, he was examined by GMCH and now this medical report is his hearing performance is totally now okay.
So?
So in this, so kindly consider the RME board for re-examine or for capable of the.
No. Parties to make their respective submission basing on essay report on the next date of listing. You make your submission.
Yes, Lordship.
You make your submission.
Yes, Lordship. Actually, this medical report to register to furnish the respondent authority. That's why the next date is for today.
I'm not getting what you want to say.
Lordship, here is the medical rejection ground. In the last order, he was examined, Honorable High Court order, he was examined by the GMCH.
Yes.
That medical report, I think, is there.
You are found to be okay.
Yes. Yes, they found to be okay. Yes.
So, you don't want to be okay.
No, I'm okay. That's why I may consider me
For
the post of Constable GD.
Yes.
So Lordship, he was disqualified by the detailed medical board and review medical board. So as per the this recruitment process, the decision of review medical board is final, and we have taken him to the specialist, and as per specialist report, on the basis of that, review medical board disqualified him. Subsequently, he went to GMCH after disqualification, and GMCH given one report that he is not suffering from that. But Lordship, then again, the Honorable Court directed him to re-examine by the doctors of GMCH. So our stand is that today he may be had recovered from his illness, Lordship. But when we examined him at that point, before 6 months, he was suffering from that disease, and that is the report of the specialist that I have given that instruction also, Lordship. And now we have to go by whatever they are at the time of the examination in a recruitment process.
So have you furnished the copy to him?
Yes, he had gone through that.
Have you received the copy?
Which copy, Lordship?
The communication.
Yes, review medical board that he had challenged.
Review medical board's report not furnished. They just indicate your rejection for the.
No. The court master is directed to furnish to the learned counsel respondent a copy of the communication.
That is given to me.
And the report enclosed thereof of the medical considering the college and board examination. Who has constituted the medical board?
Medical board.
Lordship, now on the basis of that report of this GMCH, Lordship, on the last occasion, Honorable Court asked me what our observation on that report, Lordship. So that is my instruction.
Saying what?
That at that time he was suffering, and now he may have been recovered after 6 months, but we have to go by at that time. If that has to be followed, then in near future, Lordship, a floodgate will be open and anybody can come. But at that time, he was suffering from that, and specialist report was very much there.
Who has constituted the medical board for re-examination? The person to this court order?
Yes, Lordship.
Huh? It's a pursuant to the order of this court.
Yes, Lordship.
You have not objected to that. Now, how can you turn around now? There is direction of the court to get him re-examined. Accordingly, it has been done.
Lordship.
Then,
That is, thereafter, Lordship, that Honorable Court directed to provide a copy of that examination.
so now you are saying that you are simply saying that he may be okay by now at that point of time.
That is
No,
our
that's not,
stand,
that
Lordship.
cannot be ground now, because the examination, taking into account everything, is directed by this court to get him examined. That has been examined. Now he's found to be okay. You select him now. You consider him now.
But Lordship, when we examine him, at that time he was.
Okay, but then when the matter is brought before us, this we have directed to get him examined.
That is why, Lordship, on the last occasion, Honorable Court asked us to obtain our instruction on that. That's what I have placed, Lordship. That is our instruction on that regard.
So
Paragraph 7 and 8, Lordship.
we will record it and dispose of. You consider it. See, I understand that time he might have some, but at the same time, there's a scope also that it was wrongly, examined.
No,
The
Lordship,
findings could have been different also.
Lordship, that as per the rule, Lordship, he has to be examined by specialists, which we have done, Lordship.
Yes.
And he was found unfit by the specialist doctor.
Therefore, it could be wrong also. Now, when the matter is brought before us, we direct to get it examined. That has been done. Now he's found to be okay. Now you consider.
So let that our instruction that may be reflected in the order, Lordship. Paragraph 7 and 8 that, and moreover, Lordship, the review medical board decision is final. In the last occasion, I have also given a order of the Honorable Supreme Court that is thereafter, Lordship.
No, when we have directed to interfere to get him, examine again, on that basis only you have to consider.
Further review, further re-examination of the
Not really, to consider on the basis of the latest medical report.
Civilian one. In that case, a review medical board again has to be constituted by our officers also, Lordship. Because it is that direction was only because there are two separate this, because according to him he was fit, but as per review medical board and DME he was unfit. That is why third opinion was taken.
Third opinion is in his favor, so you have to agree to that.
But when that agreement process was going on, Lordship, that in that case, Lordship.
Then you bring on record this. Heard Mr. So-and-so learned counsel for the petitioner. You don't want to consider as prayed for by Mr. MS S. Barua, learned CGC.
B. Sharma, Lordship.
B. Sharma, learned CGC. 2 weeks time is granted to file to bring on record the stand of the respondents on the medical on the report of the medical board constituted in Gauhati Medical College and Hospital pursuant to the order of this court, as the medical board constituted, the medical board of Gauhati Medical College and Hospital has found the petitioner to be fit. We consider fit to be found to be fit. Where is that report? Where do What is that report?
That is a part of the record.
No, not found to be found to be normal, huh? List the matter after 2 weeks.
Obliged.
40. Make please lawful. On the last 3 occasions, they sought for time for filing affidavit, my lord. Is today also they are.
We have sent it for vetting.
You are for?
R1 and R2.
R1 is who?
ASWC.
Huh?
State Warehousing Corporation.
Okay.
My lord,
And
repeatedly are
Mr.
such-
A Borman.
Every time
MS
this
Buzzer,
matter comes up,
Rajar Bunya, Land Counsel for the petitioner. Next para. Is spread for by Mr.
A Borman.
K.
Borman.
Bormon. Land Counsel for the respondent 1 and 2. A last chance of 2 weeks is granted to file affidavit in opposition.
my lord, the
Yes,
date,
MS.
my lord, the date may kindly be given, my lord. May it be kindly on the,
Be little louder.
on the
Can it be
17th.
little louder?
My lord, on the 17th, my lord.
Ray Talukdar on behalf of MD Bora for responding number.
As agreed to the parties, let this matter listed on 17 September 2026. September.
August, my lord.
2 weeks, how can this be?
My lord, it is the third time, my lord, they are making. It is affidavit ready. They are telling if only officer is not
17.
signing.
Okay, 17 August.
All right.
You have sent it for betting. Get it filed.
41.
May I please your lordship. My lord, the petitioner's pension is stopped due to the, my lord, the excess withdrawal of salary. My lord, kindly see page 37, my lord.
Not Mr.
Well, M Islam.
There is MCNA.
M Islam.
Islam Land Council for the Minister.
The
As
case is
provided
covered.
by the Land Council for the respondents. Further 3 weeks time is granted to file affidavit.
Hello.
Just after 3 weeks.
Provisional pension may be, my
It's
lord.
okay. We'll see, let them file.
Alia, bless your lordship.
Lordship, here in this case, Lordship, one affidavit that is sought from the pension department, Lordship. It is the instruct. 42.
Who is for the pension?
Just pension, I'm Lordship, I'm.
You want some of them?
Lordship.
Or Mr. M.H. Laskar, Land Council for the petitioner. As pressed for by Mr. U. Sharma, Land Council for the Land State Council.
Lordship, in item 42 affidavit has already been filed. It does not, it is not related to any pension, your lordship.
Just in case. Put that. And pension department.
You're supposed to bring Mr. M.S. Esborua.
They have filed an affidavit already.
Yes, what is to be done?
But some more time is required to call for some document, Lordship.
What documents?
Yes, Lordship.
You have filed an affidavit already.
Lordship, affidavit file, Lordship. So for going for the affidavit, some more documents is required, Lordship. Some documents is not enclosed with the.
What is the matter about?
Lordship, in this case, the petitioner was selected for the post of psychosocial counselor after going through the proper procedure, advertisement and everything. Now they are saying she has been selected and selection was duly forwarded to the director for approval, but that approval was not granted to on the ground that she has not the required qualification, your lordship. Now, your lordship, she has.
And what is the extent?
Lordship,
What is their extent?
they are saying that, as lordship would kindly say, that this petitioner, she is.
You have no education qualification.
Yes, she is Bachelor of Social Work and then completed her Masters of Social Work also, a professional degree, your lordship. And then, your lordship, the advertisement was issued
Lordship will find the advertisement at
Okay, heard Mr. M.H. Laskar, learned counsel for the petition. Mr. U. Sharma, learned state counsel.
Lordship, J.K. Goswami, Lordship.
A.K. Goswami,
JK.
J.K. Goswami, learned state
Additional
counsel.
senior government.
Additional senior government request for is granted 2 weeks time to obtain instruction. List after 2 weeks.
interim order may be continued.
Interim order passed, and let's
The
continue.
date may be fixed, your Lordship.
Let us see.
Lordship. Any date, your Lordship.
2 weeks. We'll list after 2 weeks.
Oblige, Lordship.
43.
Made will also.
Lordship, affidavit has been sent for vetting, Lordship, some more time may be granted to.
Another analogous, there are 8 analogous items, my lord. Some have been disposed of, I have brought the judgments. And one is fixed on 17, my that is also fixed on 17, later, in the meantime, file affidavit.
Mr. R.P. Sharma, learned senior counsel assisted by M.S.
Embora.
Embora, learned counsel for the petitioner. It is submitted by M.S. R.D.B. learned CJC for the respondents that affidavit in opposition has been sent for vetting. Therefore, fresh for listing of the matter after 2 weeks. As agreed to by parties, let this matter be listed on 17
of
August 2026. In the meantime, MS learned CJC to file the affidavit in opposition.
17 of
45 and 44 and 45.
Please, your Lordship.
Yes.
Relating to first one, your Lordship will regarding the payment of salary. But they have not paid the salary of the petitioner since November 25, your Lordship, till date, your Lordship. Subsequently, they, in that case, they have also not filed their affidavit. They have given twice chances, but they have not, till date, they have not filed their affidavit.
Yes, instruction, what is there? Why he has not been paid?
But thereafter, your Lordship, subsequently, he was suspended from services. Your Lordship.
Our instruction awaited 2 weeks time may be granted.
Where?
I mean, 2 weeks time may be granted, Lordship.
Notice was issued on April.
26 matter, Lordship.
My lord.
Notice was issued on
The first one, yeah, notice was issued. Then the second one, you will also notice was issued, but the steps has been taken. But they have not yet filed their affidavit. But then first one, your lordship, they have not paid his salary also till
Mr.
today.
Chaudhary, problem is that your case was taken up on 1st of April, April Fool. Therefore, it's pending. They are not able to install.
Neither till they have not filed their affidavit, first one. Then the second
Mr.
one also,
R.M.
your
Chaudhary,
lordship.
learned counsel for the petitioner. As prayed for by Mr.
B.C. Musahari.
B.C. Musahari, learned counsel for, learned standing counsel BTC.
As an interim
2
matter,
weeks time,
measure, your lordship
2
will
weeks
file.
time is granted to file affidavit of officer. Yes.
Then my interim prayer may be granted.
What is your entry prayer?
Remember, my suspension order may be stayed, your lordship, till then.
Is it a prayer here?
My lord.
Huh?
My lord. Second writ petition, your lordship, 3244.
Suspension cannot be simply stayed.
Due to the, due to that, they are.
Okay, thank you. We'll consider after 2 weeks. Let them file.
The record, it may be recorded, your lordship.
What? We'll consider, let them file.
My interim prayer.
Even notice has not been issued as yet.
Notice has been issued, your lordship.
When it was issued?
My lord,
okay.
Steps has been taken on 26/6/2026, your lordships.
Which one? Which item?
Second one, well, let's see, 3244.
Second, you are challenging the suspension.
Suspension order, your lordship.
Notice was issued on 05 only.
My
Oh, no, sorry, returnable.
My lord. steps has been taken 26/6/2026. But till then, they have not filed their affidavit. And petitioner is suffering, your lordship, neither received the salary, but suddenly he was suspended from service, your lordship.
Where it is? Where is the suspension order?
Suspension of the page 52, your lordship. 52. May I read it? Whereas the Gomtom Rajbangi Senior Assistant Officer of the SDO Udalguri has been found to have been irregular, frequently absent from his official duties without prior intimation or sanction of leave from his controlling officer. He has been found to be retaining official.
Very serious allegation.
No, well,
We'll see.
all are false, your lordship.
Okay, let them file. In both the cases.
In the meantime, your lordship, till
Suspension cannot be this thing.
maybe your lordship reinstated then, if anything.
See, suspension cannot be silly. What ground we should suspend there? What is the ground for? What is your case?
Case, your lordship.
Why the suspension should be stayed?
Suspension, your lordship, unnecessary. He
Not unnecessary. You are found to be remain absent,
They
unauthorized,
don't allow him to.
and then you have unauthorizedly retained the government records. Yes, very seriously.
Totally false, your lordship.
Seriously, that you establish. That's not a ground
They
for
have not filed
suspension.
affidavit till today, your
They will file. Notice was issued on when?
Recent matter.
Thank you.
2020.
Next. Call the next. Thank you.
Supplementary list 62.
My lord, it's regarding non-promotion to the post of my lord Superintendent of Taxes, my lord. My lord, I take your lordship straight to Annexure 10, my lord.
Will take time.
My lord.
It would require some time to add the matter. We'll admit and list for hearing. We'll give you a fixed date.
Yes.
So it can be disposed of.
My lord.
It's for seeking promotion.
My lord, yes, my lord. My lord, can it be?
Some time will be required to
My lord,
for
can it be-
deliberation.
My lord.
Okay,
sometime
heard
will be
Mr. PJ
Fukan, my lord.
PJ Fukar, Learned Counsel, as well as Mr. Chaudhary, Learned Standing Counsel,
Finance and tax.
Finance and Taxation Department, as well as Mr. SK Medi for Respondent Accountant General. Admit list for hearing on
11th, my lord.
11th of
11th of,
Lord,
my lord,
11, I have got some other, on
after
18,
two.
subject to my,
Huh?
on 18.
18 August.
my lord.
May I please, your lordship?
Yes.
Here the petitioner retired from as Secretary of Gao Panchayat Lordship from Bongagaon Jilla Parishad after serving 36 years Lordship. But Lordship, when his pension was finalized Lordship, took duration of 12 years has not been shown as non-qualifying service Lordship. May come to page 12 Lordship.
20.
Page 12 Lordship.
Page
12.
Lordship
at column Lordship 6. Class of pension superannuation pension. Gross service 26 years, 11 months, 15 days. Non-qualifying service 12 years, 3 days. And let's say below at 7, net qualifying service 24 years. 11
affidavit
months,
would be
12.
required. Affidavit would be required.
Yes.
And Mr. P.K. Das. P.K. Das.
Yes, my lord.
Learned Counsel for the petitioner.
Yes,
As
Mr.
paid for by
Covered,
Mr. A. Kaur, Learned Additional Advocate General.
Yes, your lordship.
For the state respondents. For the 3 weeks time is granted to file affidavit of pension. MS S. Borough, Learned State Council. For respondent 2 and 5 is present.
Obliged.
21,
Will be the two.
time being.
21.
Well, the matter is already been settled by amicably between the parties. And even so far the DCRG amount is concerned, my lord, it has been already, they agreed to accept 50-50. So earlier occasion, my lord, they took time to obtain instruction. My lord, I think, my lord, there will be no objection because it is already parties agreed. So there should not be any impediment to discharge the amount, my lord.
So what is to be done?
50-50, you have already, as per our compromise petition
Hmm.
and compromise, my lord, this agreement, we have submitted, my lord, this IA, my lord.
So what is to be done now?
This is as part this, my lord, this compromise that both should be, my lord, 50-50, my lord.
Yes.
But the TPU is issued only in favor of the first wife, Lordship.
Huh?
No. Initially, not, my lord, there is some mistake, my lord. Actually, my lord, the DCRG was given to, my lord, the, instead of the petitioner as well as my 4 children and the other, my lord, legitimate children of the second wife.
2 o'clock. You wanted it should be disposed of
Yes, my lord, that should be disposed
on the basis of the agreement.
Yes, my lord.
Okay, it should be. There is no dispute as regarding the payment, except the apportionment.
DCRG, yes, my lord.
Dispose it of.
Pension will go in my favor, but the DCRG that can be, my lord, all children also entitled, my lord, eligible.
As per the agreement will say,
It is, my lord.
That can be done.
you have brought in the agreement.
Yes, I have brought my agreement. I is there. Master, please.
Lordship, in item 23, if I may pray for a date.
23, what is that? Legal aid counsel. I have recorded your name. Give the bed, item 23.
My lord, one small.
2 o'clock.
My lord, one small bear, my lord, item 20.
2 o'clock. We'll dispose it of. Heard, Mr. Item 20. Imanda. 21.
Yes.
Let me consult for the petitioner and also heard
Arboro, Lordship.
Mr. Arbor, learned
For
consult.
reference number 6 and 7.
Respond number 6 and 7. Who is appearing for the state? Anybody for the state? Where is this orders?
Which one, my lord?
Hmm?
This is my impine order, my lord.
Hmm.
My lord, I have annexed in again in this, my lord, the annexer 8 page 23, my lord.
And IA.
I
No, you come to a writ petition.
Great picture, yes, my lord. This is, my lord, page number, annexer 8, page number 23, my lord.
20?
23.
23. You are challenging this.
Yes, my lord, because, my lord, the total children of this, my first wife side, including the wife, is a 5 years, and the, my lord, illegitimate child from the other wife, my lord, is a 4. So actually, my lord, that should have been in 9 equal share, but that was, my lord, done, my lord, excluding the 3 daughters of the first wife and including the all illegitimate child of the second wife. Well, so that is why the dispute was there. So it is not entitled. However, my lord, the amicable settlement has been arrived in between the parties. And as per that, when we get a settlement, now we have decided to take in 50-50, my lord.
Communication. No, by filing this writ petition, the petitioners,
Yes, petitioners.
petitioners
5 petitions.
have challenged the communication dated 12/11/2019 issued by the senior accounts officer, Office of the Accountant General, Gauhati, whereby the Treasury Officer Haplong is directed to arrange payment of a sum of rupees
5 lakhs,
5 lakhs
10,000,
10,400
408.
408, page 23. In respect of to the petitioner and other legal heirs in equal share in respect of late Ajodhya Chauhan, former ex-field investigator. List of the petitioner is the petitioner is the legally married wife of first wife.
First.
You are second wife.
No, he is one of the AZ, my lord. The other private respondent, they are from the second wife, my lord.
Wife is not before us. Second wife is not before us.
No.
Okay. Who is for them?
They were, my lord,
Nobody.
they are, my lord. They are appearing, but I don't know why after the agreement signed between the parties.
Respondent number?
This is, my lord, the respondent number. This is 8, 9, 10, 8, 9, 10, 11, and 12, my lord.
8,
8, 9,
10, 11, and 12.
12, yes, my lord.
5.
My lord, this is 8, 9, 10. This is 4, my lord.
8 to 12.
Yes.
8 to 5.
5, yes, 5, my lord. 8 to 12, 5.
5 kids, 5 children.
No, 4 are children, 8 is my lord second wife.
Okay. Of late Ayodhya Chauhan. Who was working as field investigator in the office of district social, under district social welfare department, Haplong, in the then NC Hills. Now, what is this? NC Hills is now?
It's NC Hill, my lord. North Kasar Hill district, my lord.
Huh?
North Kasar Hill district, my lord.
No, now it's earlier it was NC
Earlier
Hills.
that was
Now
same. Dima Hasa, my lord. Now Dima Hasa, my lord.
within bracket, now Dima Hasa. Bracket close. List from the said marriages, from the said marriage, the petitioner please out of the petitioner and our late husband have 3 daughters and 1 son. List of next paragraph. In the year 1989, the late husband of the wife had contracted a second marriage is contact the second marriage to the respondent number 8, out of which 4 out of which 1 son and 3 daughters have been. And out of which 1 son and 3 daughters have been born. This stuff. Next para. In the service book, whose name was there?
Service was only my name, my lord. The first wife, this Sanmati Swan.
Next para. It is the case of the petitioner that the petitioner being the legally married wife whose name has been entered in the service book of her husband late Ayodhya Chauhan, would be entitled for pension benefits, including DRCGS of rupees 5,10,408, along with his children, along with her four children. Rest of the respondent number 8 being not married legally, and the children's born out of such wedlock being illegitimate children do not have any right to claim for any retirement benefits, including DCRG. List of next para. The respondent authority by the impugn order, that is next para, 12/11/2018, directed the Treasury officer of Mahaplo to arrange payment of the DCRG for a sum of rupees 5,10,408 to the petitioner, along with the son of second wife, 2 daughters, and the son of petitioner. List of. It is submitted. No, list. List of. It is contended that the such order for payment of DCRG amount of rupees 5,10,408 to the children and children of the petitioner, children of the respondent number 8. With that, by depriving the daughters of the petitioner is illegal. Next paragraph. During the pendency of the writ petition, the parties have entered into a settlement as regards the, what is that is?
My lord,
What is the settlement?
IA, my,
Yeah.
IA 866, my lord.
Page 13.
Yes, my lord.
Entered into a by way of deed of compromise on 27/01/2025. Which is reproduced here in on the page 13. Page 13, 15. Next paragraph. It is next paragraph.
Lordship, after this agreement, we have already issued DCRs in favor of both the first wife and second wife. We have filed our affidavit in this.
Is it so?
Lordship.
Then nothing remains.
It is now, it is with the Treasury officer here.
Okay. It's okay. You are appearing for
I am for Accountant General.
Accountant General. And
Correspondent 1 and 2 lots.
you record your name also, huh? A. Chakraborty
One
and H. Alia for Finance Department. Quotidian. Next bit. Then Council, Mr. P. Mahanta, as well as then Council for the petition and Mr. and they are all in them. Clearly submitted that in view of the settlement between the parties, the petition may be disposed of, directing the respondent authorities to make payment in terms of the said settlement. Next paragraph. Upon consideration of the matters in its entirety, and in view of the
We have authorized.
settlement
Lordship, we
between
have-
the parties, I'm of the considered view that nothing and no issue remains to be adjudicated upon, as the parties have settled the matters between amongst themselves for payment of the DCRC of rupees 5,10,408 on 50/50 basis.
Here, Lordship, we have issued 2 GPO.
It's
One
okay,
intake-
we're not concerned. They'll do it. Next paragraph. In view of the writ petition stands closed with a direction to the respondent authorities to make payment of the DCRG amount of rupees 5,10,408 on 50/50 basis to the parties strictly in accordance in terms of the settlement dated 27/01/2025. Within a period of
Lordship, we have already issued.
It is
from
by,
our end.
it is
may
by the
be
Treasury Officer Dimahasa.
within a period of
25.
20 days from today. 20 days from today.
Why
There
not?
will not be any impediments.
Yes, but this was sent in the year 25.
25 itself.
Therefore,
That was not released, my lord.
2020.
My lord, that may be kept open, my lord, for claiming the interest because of their fault, I am suffering, my lord. That's
You will
it.
not say anything.
Because, my lord, because their
No,
fault,
your
I am not on that, my lord.
We are not saying
That
anything.
this is their fault, but I am suffering. This is the case.
In view of the.
No, my lord.
I,
Wrong
in
in,
view
my
of
lord,
the
issuing of
disposal
the DCR.
or the WPC so and so, I stand disposed. Huh? Yes,
There was interim of the Your Lordship.
obviously it will merge along with that.
Last of this.
Then last whether it needs to observe that interim order was shall merge along with this final order.
I'm even happy, my lord. This is the interest portion will keep it up. Because of therefore, when I am suffering well from last 3 years.
Nobody is stopping you.
The definitely,
You may
even then,
approach,
even
you
then,
may claim, and if not,
because
don't
they are because of their
at least
fault.
you don't come back here. Approach
3
the
years I am
appropriate
suffering, my
forum.
lord. No, my lord. They compel me to come before your court, my lord.
It's okay. Will not say anything. Six. Any difficulty?
My lord,
Any difficulty?
the difficulty today I have because all the along I was in court number 1 without SC. So that is another matter. But my lord, there is an order.
Saying what?
I'll kindly go through it.
What is there? It should not be listed before me.
No, that I am not sending. I have also heard that there is another circular, but that circular I could not find out because after coming to court, I have come to know.
What is this? A supersession order, Honorable Chief Justice, has been released to order that the evidence for all part heard matters after expiry of 1 month, restrained released from the respective benches, and such matters shall be taken up by any other. What is the fault of this court?
No, that
has
is
not been rostered
that
here.
is not the matter. That is why
And
I
you
am
have not prayed for VC.
only on the order of Chief Justice.
Okay,
nothing
we'll
else.
say, Mr. M.U. Muhammad, learned counsel for the petitioner, by placing the
I have also heard that there is another circular, but that circular is
placing
not with me.
the no, will not say anything else. You take it, you keep it yourself. Submits that he has some personal difficulty today to argue the matter. Although although matter was heard at length and kept the same as part heard, only to provide the land counsel for the petitioner to address this court on the on certain issues, on the prayer of land counsel for the petitioner. Let this matter be listed after. Let this matter be listed after 4 weeks. Matter stands released from part heard.
All right, sir.
Item 46 for order. This case was filed by the ASTC, my lord. We were supposed to pay 1,43,991. This is the part of the retirement benefit of a particular person, my lord. This Mr. Khurshid Alam. And in a scheme under the government, whenever we get money, my lord, we used to pay proportionately to all the retired persons, my lord. On 5/6/2026, the due was only 1,43,991. There is a single seat, your honor, loose seat in the file, my lord.
Loose seat?
There is a loose seat in the file.
IA? In the IA?
In the IA, my lord. That lordship can see on 5/6/2026, my lord. This is the amount was payable was 1,43,991. My instruction is, my lord, we have not received money from the government to pay all this. Yes, this is a dying organization. My lord, what I sincerely pray, my lord, if your lordship is pleased, my lord, to give us 4 weeks time, my lord, during this 4 week, we'll be clearing this fee.
We will not say anything. The IA for what?
IA, my lord, for extension of the time that was given to us.
Okay. So should we issue notice? Is it coming
No,
for the first
notice
time?
is not required, not the first time.
Why?
It's an old matter.
Non appears for the prisoner on call. I will not say anything.
So lordship
notice has been
simply
issued.
adjourn it for a 4
No,
weeks.
Notice has been given to him.
My lord, they appeared earlier, my lord.
Okay, so we'll not say anything.
No.
We'll adjourn it on your prayer. You do
For
it
4 weeks.
within- As prayed for by Mr. H.M. Learned Counsel for the petitioner. List these matters. List the alia, intellectual application. It dispose of, right? Dispose of matter.
No, the writ petition was disposed of. Then they are in.
Yeah. What I said? On the prayer of Mr. H.M. Learned Counsel for Standing Counsel.
Yes, ma'am.
Standing Counsel ASTC for applicant. Let this I be listed after 4 weeks.
4 weeks. I'm deeply aware.
May I please? Mr. Chair, this contempt petition is pending since 2024, my lord. And every occasion they are taking time, my lord.
Yes, Lordship.
You're supposed to obtain instruction.
Lordship, today, my senior is not feeling well and he's on medical issue. So Lordship, may kindly fix the matter on next week.
Next week.
Every occasion, my lord. Since
We'll
2024,
list after 2 weeks, you obtain instruction.
last chance may be given.
Not Mr.
HL Ashkar, my lord.
H.L. Laskar, Learned Counsel for the Press. Next para. Mr.
R. Sahana.
R.
R. Sahana. R. Sahana.
Ah,
I'll write.
Learned Counsel appearing on behalf of Mr. D. Nath, Learned Counsel for the alleged contempt. Submits that Mr. Nath has some health issues today, therefore he could not be in the issues today, therefore is unable to attend the court today. And as such, prays for 2 weeks' time. List of next considering the matters pending since 2024. No. Consider the submissions. Having considered, in be above, let this matter be listed after 2 weeks. In the meantime, on the next day, Mr. Nath, the counsel for respondents to place the instruction.
Last chance may be given, my lord.
I'll obey, Lordship.
Lordship, last chance may be given since it is
Agency.
pending since 2024, my
It's
lord.
all right.
Most of them.
49.
May I please, Lordship? 14 and my lord, though steps are awaited, my lord. My lord, will kindly have a look. My lord, they mounted a challenge on the single bench order, my lord.
Huh?
The order which is under contempt, my lord, the union assailed order also. Dismissed, my lord. That order which I filed contempt, my lord, that was assailed before the division bench. And that was also dismissed, my lord. And those party structure, my lord, the Lordship will kindly see the appellants. It's a recent order of 22/7, my lord. Though they are not appearing, my lord, they are fully aware of the proceedings because they had preferred that appeal, my lord.
No, what is the status?
Contempt, my lords, I check with the records, my lord, it says services awaited. But my lord, they are
Take press steps.
my lords, they are willfully, my lords, they are
You
not
take
appealing.
steps.
My lords,
With 7. Concerned parties 7.
7, my lords, they are
You take press steps.
first steps, my lords.
Mr. D. Govay, Learned Counsel for the petitioners. Press for and granted a week's time to take press steps for service of notice upon response number 7.
7.
List after 3 weeks.
Fixed statement given, my lords.
3 weeks.
I'll check with the court master. Obliged, my lords.
Item 50.
And regarding payment of minimum pay scale to the, my lord, petitioner.
Contempt.
As per Upendas. Now, my lord, Upendas has been interfered with by the Honorable Supreme Court.
Saying what?
My lord, saying that, my lord, that order is
You
not
bring
success-
out record, you have filed the affidavit.
My lord, here, the deliberation is going on in the department as to what next course of action will be after the Upendas has been interfered.
Minimum pay scale of
Interfering
pay.
with the Upendas judgment, the Honorable Supreme Court has directed us to regularize all the appellants
Ah.
instead of minimum pay scale.
Ah.
Whoever was engaged prior to 1/4/1993. But but the petitioner herein is a beneficiary of Upendas. So we are in a dilemma, my lord, what to do, my lord, whether we continue with Upendas, but paying minimum.
State is so helpless or what? Huh?
No, I'm just saying, well, they are having some discussion on that point. So I pray for at least 3 weeks time, my lord.
We'll give you 6 weeks.
My
No,
lord.
no, my lord, kindly 3 weeks, my lord. Already they have stated before this honorable court
Yes,
that
their case has been considered.
only my lord cabinet decision is necessary. Now they are
That's
taking
why
this
that
order.
part is pending, my
Okay,
lord.
anyway.
All the time they are taking time
Had
after
MS
NS Thakuria.
NS Thakuri learned concept for the petitioner. Next para.
I appear for 5.
Mr. B. Gogoi learned concept for the respondent Alice contemporary number 5
5, finance.
submits that in view of certain developments as regards the case of what does Upendas and the judgment and order of the Honorable Supreme Court, comma, the state is examining the matter. Therefore, request some time and accordingly praise for 2 weeks, 3 weeks time.
Let it be 4 weeks, my lord. please.
No, my lord,
Yeah,
kindly
please for
3
3
weeks,
weeks,
my
let it be
lord.
4 weeks. my lord.
Already taken so much time.
They'll not do in 3 weeks. Assam is
Obliged.
Assam is called land of Lahe Lahe,
Lahe lahe, yes.
No, no.
without any prejudice,
Actually, my lord, because
without
the
attaching any other meaning. But we just heard like that, we don't know.
No, that's not true, my lord.
Please consider above, let this matter be listed after 4 weeks.
After 4 weeks. my lord.
Can a date maybe fixed, my lord?
Yes, it's better for you also, so that you
Yes, ma'am, we can work on it.
give after 4 weeks.
Yes, September, after 4 weeks from today.
9th.
Let it be 11, ma'am, we'll get the entire. week.
11, yes.
Obliged, my lord.
Yes, madam.
Lordship, no affidavit has been filed.
Yes, why?
Instruction from ZAD department was required, Lordship, and SC ZAD is not shown in the cause list. Lordship.
These are all
We have sent a proposal to ZAD department, Lordship, and instruction.
the excuses. Anyway, heard MS. You are there now?
Yes, we have received instruction. As per our instruction, the proposal has sent to the ZAD department, Lordship.
So you would like to file a petition, I mean
Yes,
affidavit.
Yes, sir.
Who has to take care, in fact?
ZAD department.
You are not GAD.
No.
Who is GAD?
Preparing for 1 and 3.
Who is GAD?
A Fukon generally.
Appears, Lordship, he is not well, Lordship.
Well, granting, will record his name.
But while informed,
Well, I'll record your name.
Lord, yes.
Just inform her.
Yes.
At MS M. Dev, learned counsel for the petitioner, as prayed for by Mr. MS S. Bora.
S. Borua for
S. Bora,
3.
learned state counsel.
Yes, Lordship.
State counsel for respondent 1 and 3, and Mr. A. Chalia, learned counsel, appearing on behalf of Mr.
A Fukon.
A. Fukon, learned standing counsel,
Yes.
GAD. Further 3 weeks' time is granted to file affidavit in opposition.
Public.
Lordship, the name of SCGAD may be reflected on.
Registry to reflect the name of SCGAD in the cause list.
Public.
53.
Review of what?
My lord, basically we are for a review application has been prepared, my lord.
For what?
For the review and reconsideration of my lordship's order, my lord.
What is
My lord, the case, kiba kobo.
Where is the review? Where is the order?
My lord, the order of review, my lordship may be pleased to find is at page 48 of the petition, my lord.
This IA.
No, my lord, IA for the condonation of delay, my lord, what has happened, this order was passed on 28/5/2024, my lord. So therefore, my lord, we have also preferred an IA for the condoning the delay. My lord, the registry has calculated the delay is about of 705 days, my lord. So, my lord, in this delay, if my lord.
What is the matter? What's
Yes,
wrong here?
My lord, the matter about is a compassionate appointment in the army, my lord. In the Indian Army, my husband, my lord, has been relieved from his, my lord, capacity due to the medical ground, my lord. And my lord, in the rules, my lord, which has been prescribed, that in such a situation, the dependent family member is entitled for the compassionate appointment under the army rule, my lord. So, my lord, when this matter was heard, the issue has been, my lord, construed that I had been superannuated, not relieved, my lord. And on that context, my lord, we have come again to show my lordships that the records and the document, my lord, which we did rely at that time, my lord, was, my lord, due to inadvertently or for the some reason, my lord, it could not be considered by my lordships, my lord. So therefore, my lord, we are again before my lordships that placing that record, my lord, to show that I did not superannuate. Rather, my lord, I was relieved on medical ground, my lord.
Lordship, I am appearing for all the respondents on behalf of Mr. H. Gupta. Lordship, we will file a memo shortly, and also, Lordship, we wish to file an objection in the IA.
Okay, heard, Mr. Here, Learned Senior Counsel assisted by Mr.
H. Laskar, man.
Huh?
H. Laskar.
H. Laskar, Learned Counsel for the petition. Will issue notice in the,
My
the or notice has been issued
No, my lord, this is the first time before.
in IA, huh? This is the application seeking review, seeking condonation of 707 days.
My lord, my lord.
Seeking condonation of delay of 707 days
That's a 5 kg.
in filing the connected review petition. Against the judgment and order dated 28/05/20, against the order dated 28/08/2020 passed in WPC.
Austin
3349 of 2021. List of issue notice returnable by 3 weeks. Next period. You are appearing for all as MS
P. Agarwala on behalf of Mr. H. Gupta.
P. Agarwal, Learned Counsel, appearing on behalf of Mr. H. Gupta, Learned Counsel for all the respondents. Enters experience and accepts notice or no form and notice need be served. Next period. On the the respondents may file their objection, issue advice. Less after 3 weeks.
Mal. Obliged.
The review, we don't have to pass any order, huh? Unless it is condoned.
Lordship, in this matter, on the district commission, on behalf of district commissioner and IA has been preferred, Lordship, for modification of the order, Lordship, which is in annexer, page number
In this
19, Lordship.
matter, it has come for the first time. I'll file a reply. The entire matter can be taken up for a final disposal because I have also not received.
If you want to file objection, we'll issue notice.
Lordship,
Yes, yes.
that is short, not
Sure,
short.
Lordship, what I will pray, Lordship, this, I'll file reply in the main matters also. It can be taken up for the final disposal because for the
The
last.
first we'll do is,
Yes.
is for IA. Formally we'll issue notice. And Mr. MS M. Bhattacharya, Learned State Council
Lordship,
for the applicant, next para. Decision application seeking modification of the you are only seeking for modification.
modification of 10/4/25 order, Lordship, because the petitioner,
Not for
Lordship,
not for
yes.
vacation.
Vacation, Lordship, if Lordship modifies.
Vacation of
only
the vacation.
this much, Lordship, yes.
Of the order dated 10/04/2025 passed in WPC 2015 of 2025. Issue notice returnable by 2 weeks. 2 weeks.
2 weeks.
As Mr. BP Bora, Land Council for the Land Council entered the experience and accepts notice on behalf. Respondent one only.
One.
Respondent. One. Respondent. Sole respondent, no formal notice need be served. Next, but the Land Council for the respondents may file objection if any. List after 3 weeks.
Deeply obliged.
Actually, in the main matter, I'll also file a reply in both matters.
You
Filed
file,
1 year back, Lordship. Till date, they have.
You filed
not any-
why?
Yes, because I have not received my salary for the last
Okay,
night.
today it is listed for order, so
Yes.
I mean, I only.
Yeah.
You file,
Okay.
we'll stop you.
Okay.
56,
Deeply obliged.
item 56.
56, B Sharma, Land Council. No affidavit. You don't want to file affidavit. Objection, anything? Anyway, non appears for the petitioner on call. Mr. You are appearing. Mr.
I am for a revenue department also. My lord, that matter was disposed of. My lord, that they file IF for, I think, my lord, is a correction or modification of this order. Or
No, who is there?
this is the, my lord, 2025.
No, who is there? Who is for
Petitioner is absent.
non appears for the petition on call? Next one, Mr. Ukhan. Sorry.
J. Handy for,
Sorry, J. Hendik.
for revenue.
Standing Council.
Lordship.
Standing Council FDP and Mr. H. Chakravarti staying are present. List after 3 weeks.
Obligation.
57,
In 57, as per the office note dated 23/7, all service has been complete. Lordship. Has been served. It
Heard
can be listed for
Mr.
admission.
PP Bora, Land Council for the petitioner. And MS,
Deborah,
Deborah,
Department,
Standing Council,
Health Department.
Health Department, Health and Family Health Department, as well as MS. Huh?
Please show it on behalf of Mr. J.
Ah,
For the Kavya on the ordinance.
Lordship, in this matter, he is retiring soon, therefore I will pray for a date. Lordship. It is convenient.
services are complete. List for admission after 3 weeks.
In the meantime, I will file my affidavit.
In the meantime, parties may exchange their feelings.
Obliged.
Okay, 64 and 65.
Where is it listed?
My lord, this is a matter, my lord, relates to
List
selection.
for what today?
My lord, list for, my lord, actually it has been come in the order column, my lord. Required to be come the admission hearing, my lord, and affidavit has also been filed, and my lord, we would like to file a rejoinder, my lord.
You have not filed amended course title.
My lord, perhaps it had been submitted, but it has not been recorded. My learned colleague is, my lord, not well today. He is.
And Mr. A.R. Buya, London Senior Counsel assisted by Mr.
Yes, Abdullah.
Sir?
Yes, Abdullah.
Sir Bill, London Counsel for the petitioners. Next, office note dated 01/08/2020 indicates that no amended course title has been filed by the petitioner. As prayed for, this matter after 3 weeks. In the meantime, petitioners to file amended course title. Mr.
S. Islam
S. Islam,
for private.
no. Then, which one?
2 and 3 lots.
Mr. J. Hendik, SC Revenue Department, Mr. A. Chakravarti, is the council for 2 and 3, as well as Mr.
S. Islam.
S. Islam, Land Council for respond number
4267.
5. Your name, please. Jeff. Jeff. Are present, you just say, huh?
Obliged.
Daily 60 and 61 for hearing.
We have received some fresh instructions, my lord. We would like to bring that on record to additional affidavit.
What's the matter about?
Matter is,
My lord, this matter relates to arrear salary and also the monthly pension, all the pensionary benefits. It has been fixed for hearing continuously for 6 to 7 times. All the pleading is complete, my lord. My respectful submission, he is suffering a lot, my lord.
It's okay, and you have retired when? How many?
17.
1 person.
Only
Only one.
my lord, I have been retired on 31st December 2017.
17.
17, man.
You have filed why this much of voluminous?
Yeah,
Why this is voluminous?
This is the third litigation, my lord. Third litigation arising out of the first WPC case, and that has been disposed of.
Saying what?
At the disposal of, my lord, in compliance of the first judgment, they have within the outer limit of 3 months, and a departmental inquiry was started on 14/8/2009. According to the statement of allegation, that means the unauthorized leave, according to them. But I had taken leave on medical ground, my lord, on the two conditions: that I have lost the vision of my right eye while I was working under the department due to the complete negligence on the part of department. I have lost the vision of the right eye after 5 operations. Only through one eye. As soon as I have,
It's okay.
then secondly, my lord, I was suffering from serious bronchial asthma.
No,
That's why, my lord,
was there any departmental inquiry?
I had to take leave on medical ground.
No, there was a departmental inquiry.
Departmental inquiry started on 14/8/2009.
So you have dismissed.
No, my lord. They could not complete the inquiry for continuously with effect from March 2008 till the date of filing of the first WPC case in 2016. I have been deprived from my legitimate right to receive my salary. Then, my lord, I am compelled to prefer the first WPC case.
Then,
That case, after hearing both the parties, Honorable Court has passed the judgment. A second opportunity was given to them
to
start
complete
to start the departmental inquiry again from the date of 14/8/2009, which was started earlier, and second opportunity was given. But that inquiry must be completed within the outer limit of 3 months.
so that has not been
But they
done.
could not complete.
Then-
After about more than 8 months, then 9 months, they have submitted an expert inquiry report, and the date on which it was prepared, there was no mention, and that was after filing the contempt case. And
Then-
willful and deliberate violation of the judgment and order.
Then-
And another respectful submission before this honorable, as per said judgment, my lord, the admitted amounts should be, they were directed to release the admitted amounts. That means arrear salary about that. Then immediately after passing this judgment, my lord, a very nominal amount of rupees 74,000 has been paid initially after passing this judgment. But that was not the admitted dues. That was not calculated as per ROP rule 2010 and 2017. That is another violation. And
So department proceedings, there's nothing.
No, my lord. Now, my lord, I was not allowed to put signature in attendance register while I had
No, what
joining
will
my
be the outcome of departmental proceedings? Whether there is any departmental proceedings? Any department proceeding? Has the departmental proceedings been?
After filing my contempt case, they have filed a expert inquiry report.
Then?
And that expert inquiry report, after filing my contempt case for the first time, in order to get relief from the personal appearance.
It's all right. What had happened about the
My lord, as per that departmental inquiry, and ultimately 7,29,000 and an arrear, advance amount of arrear amount has been sanctioned. 7,29,000. But that was not my arrear admitted dues. And that I am entitled to receive from March 2008 till my
Sir,
retirement.
what happened to the disciplinary proceeding? Whether this was concluded or not?
That has been concluded. There is no
No penalty.
So
No penalty, nothing.
There is nothing. After closing the expert inquiry, let me submit. After closing the.
No, no, I just wanted to know facts. We are not clear. Yes, tell us.
Yes, my lord, the entire controversy is arising out because petitioner is not agreeing to his pension calculation. One pension he is already getting, my lord. A PPO has been issued. Only thing is there has been long periods of absence by the petitioner. Petitioner, my lord, claims that it was because of medical reasons. This inquiry report only says that there is nothing on record that he applied for medical leave or anything submitted. So no action taken against him, but only thing is his unauthorized absence could not be regularized because there is no documents. That is why, my lord, now petitioner is saying I should have been regularized during that period. I should have also been promoted. Based on that promotion, I should get a fresh salary, fresh pension. My lord may look at the prayer of the writ petition. My lord. 6, 7 issues are there. It should have been different writ petition. All those issues are clubbed together.
I want to submit before this honorable court, whatever my learned friend has submitted, that.
What you would, what new documents?
Expert inquiry report.
I have received documents regarding which leaves were approved, which leaves were not approved, my lord. Let me bring it on record, my lord, then we can end this proceeding.
See, you have so many prayers. Cannot be granted like this.
My lord, actually what happened?
Leave has to be regularized.
Just I want to make it.
Unauthorized, the absence period has to regularize. Then on that basis, you are deemed to be as a regular, continuing in the service.
That's I want to make.
And then you want to get a promotion. And thereafter consequential salaries and.
I have submitted my written argument in compliance with.
So what do you want?
I want at present. I want, my lord.
You want one or two?
No, I want at present, by setting aside the expert inquiry report, by regularizing my leave period, I am the area salary may be released from March 2008.
Inquiry could not be concluded
there are two
because
phases, my lord.
he has retired. Is it so?
Yes.
I am also entitled to.
No, why you have not concluded?
Inquiry report is submitted, my lord, which my learned senior is saying ex parte.
No, why you have not concluded? What's the inquiry report is submitted?
Concluded, my lord. It is annexed in the writ petition. That
concluded and what? Any penalty, any decision?
No penalty. Only thing is, my lord, some of his absence period do not have any documentation. So only
Whether this is concluded or not? It was a disciplinary proceedings or just mere inquiry?
It was a disciplinary proceeding.
Then why it has not been concluded?
No decision.
When you have the inquiry report?
Report is there, my lord, and the decision is that based on his earlier service, he was given pension and everything, all his benefits.
That's the only decision.
Yeah, that is the only decision.
My lord, superintendent engineer, he himself stood as a prosecutor as well as the judge. There is no disciplinary authority.
So that's why no punishment has been imposed on you. Any punishment has been imposed on you?
No punishment, my lord.
Then
my punishment is his punishment. I have been deprived
by the disciplinary proceedings.
No, I was not terminated service. But why I have been deprived from my legitimate.
Sir, I just wanted to know a simple question. Issue. Whether the departmental proceedings has been concluded or not.
Now, according to expert inquiry report, which was submitted before that was concluded. Thereafter, no final.
It's not a conclusion. So submission of the inquiry report.
As per inquiry report, a nominal amount has been paid. I am entitled to receive the actual arrears.
What is that final decision?
I have calculated, my lord.
Any order has been passed on the inquiry report?
No order because no penalty has been imposed on petitioner based on his service record.
That means it's not concluded. You just get it abated only. You did not conclude the departmental proceedings. See, when it is initiated before retirement, you have to conclude it. There's no order. After the inquiry. Inquiry report.
There was no order, my lord.
Nothing.
Nothing. Consequential order. There is no consequential order. No disciplinary authority has passed any order. The same inquiry superintendent engineer, he stood as an inquiry officer and he
recorded in a previous proceeding.
And he had,
That,
and he had admitted,
no
my lord, due
penalty
to the
has been
fault on the
imposed.
part
That
of the
was
assistant
recorded, my
executive engineer, the entire matter could have been settled earlier, but due to the fault on the part of the
You
assistant.
tell us what you want.
Now, at this stage, my lord, now I have nothing.
Not
to say.
at this stage.
My respectful.
Finally, what you want?
At this stage, my lord, I have my humble submission, my lord, that the area salary which is now I have calculated here as per table 1, 2, 3, and 4, 5. I am entitled to receive about 1 crore rupees per 5 lakhs.
What is their stand?
They have stated that as per the expertise inquiry report, the amount has been paid.
Matter of records.
That is matter of record. All the time matter of record. But it is a matter of record, my lord, is if it is a matter of record.
So
But my lord, ROP rules
Therefore, we'd like to file them additional affidavit.
additional affidavit, no. An affidavit has been submitted. I have submitted rejoinder.
And
Lordship, kindly
they are
see-
filing additional affidavit. Heard Mr.
S. Sharma.
S. Sharma, learned counsel for the petitioner.
Yes.
After hearing the learned counsel for the parties at length, I deem it appropriate to grant further 3 weeks' time to file additional affidavit on behalf of the state respondents as the claim and counterclaim of the parties, a claim of the petitioner
Yes, I have already.
is not specific, and there is no clear reply to the claim made by the petitioner.
My lord, already I have
Next, please
already I
stop.
have calculated.
Mr.
I bought it.
Thakur, Standing Counsel Forest Department.
PHE,
Huh?
PHE, Public Health Engineer.
PHE Department to file the additional affidavit, bringing on record
My lord,
all the relevant
another my respectful service.
documents
Another
in the matter.
And this is, what happened, my lord? They are going to fix the provisional pension as my regular monthly pension.
Let them bring it, we'll see. But you decide yourself first
Yes, ma'am.
what you want now.
No, my lord, I have prayed already submitted.
Not all those, it cannot be. First, your claim is that this absent period should be regularized.
Yes, my lord.
Then promotion,
Then promotion.
then consequential. That
Two
cannot be. Be specific to your prayer. That cannot be. Regular at best, we can understand.
No,
If it is under the rules, if it is permissible.
My lord, 2 prayers.
Sir, please. If the rules, if it's permissible to regularize your period, because they have not found anything, they have not on the basis of disciplinary authority, inquiry report, they have not imposed any penalty, they have not taken any decision. If that be case, if that is the case, if it is permissible to regularize your absent period,
Leave periods.
not leave period, absent period, absent or leave period. At best, you may be entitled for financial benefits, not other. I'm not promotion and other thing. So it will be quite. I mean, it will be difficult to grant your relief. Not grant. Forget about granting. It will be difficult to consider your relief. I mean, claim. So be specific. Whatever you are entitled under the law, please advise your client, litigant. Whatever you are entitled to under the law, you will be granted. Not every, I mean,
My lord, at present only I am
everything
entitled to
under the
receive
sun you
a
can
year
ask.
salary under ROP rules. ROP rules 2010 and 2016.
Maybe you may
that is I have calculated.
But then
That is not paid by me.
why you are saying that first regularize the leave period and then promotion, then consequential financial. That cannot be.
My lord, that includes within that period.
No, that cannot be. Anyway, I have not recorded. I'm just for your interest only. I'm just.
My lord, it is a very serious matter. That's why I'm telling.
It's not serious.
For last 9 years, he has been deprived. By losing his visa, he in the Gadison list, his position #1. He has been discharging his duties very sincerely and honestly.
Have you challenged the inquiry report?
Yes, I have silence here. I have silence.
Of course, they have not acted upon it.
The expert inquiry report as per law, so I have cited the case laws, my lord.
Ah.
I have cited case laws.
Okay, thank you. After 3 weeks.
My lord, date may be fixed, my lord.
3 weeks.
19 August.
Please,
19 August.
Mr. Bhatta, be specific, clear.
My lord, I'll take it to.
Whatever he said,
19 August.
19.
19 August.
I think it's not possible. We have fixed so many matters.
We only in the September, man, because his prayer is manifold, man. To specifically address, my lord, we need some more time. September.
Yeah, that may be fixed. Convenient, that may be fixed.
10th September. 10th.
10. Oh. Must have.